With the consent of aforesaid, I beg to mention item number 49 of today's list also. This matter, Lordship, a report was called for from the Sibsagar.
Call for from Sibsagar PS Malad, it is not listed. Kindly
49
Lord.
49.
report as called for has not been received. List again on.
First,
Interim order was there, Lordship.
Earlier to continue.
May please Lordship, the item number 18 Lordship. 18, 23 and 34 Lordship.
18.
18 Lordship. CD was called for, CD is not available. Or Gauhati Lordship.
18, 23,
23, 40, 34.
30.
34.
We did not
Did not receive
receive
my-
list again on.
And 7 Lordship. 7 Lordship. 10.
Yeah, please. Lordship, I beg to mention item 39, Lordship. This case, up to that case, that was called for, Lordship.
Yeah.
39.
39. 39 CD not received, madam.
Yes,
Up to date CD not received. List again on.
petitioner is a interim, Lordship. He appeared before the IO, Lordship.
Huh?
39 must search date, madam.
Targeted.
Lordship.
Interim, Lordship. He appeared before the IO,
No,
Lordship.
no, wait for your turn.
Much of Lordship.
May please, Lordship. Lordship, with regard to item number 32, Lordship, 32. Lordship, Mr. AKB has some personal difficulty. I'll be adjourned for 2 weeks, Lordship.
2 weeks, my lord. Here
Three-
CD is available, my lord. So kindly a week's date may be given, madam.
Lordship,
The date it is.
Next Tuesday. Huh?
Fine.
four
Yes.
Lordship, interim order may continue, Lordship.
With your lordship, I beg to mention item number 55, your lordship. There's some difficulty on a part of the lordship. May I pray for it? The matter may be listed next week, your lordship. 4th or 6th.
Already. Here for
Petitioner, your lordship.
the side?
Others are informed, lordship. You're aware.
Yes.
4th or 6th, your lordship.
Lordship, I beg to mention item number 24. Lordship, it was fixed for CD not received yet.
24 CD.
Lordship, there is an interim bail.
26 also, my lord. 24, 25, 26.
Yes. Yes, interim to continue. List date to be.
May I, Your Lordship, item number 35, Your Lordship,
Ah.
of CD, and CD has not been received.
5
30,
35,
35. CD not received, my lord.
list on.
and I'm in interim, Your Honor.
Interim to continue.
Please, Lordship, I would like to mention item number 2 of the daily list. The matter may be adjourned for the possible, it may be fixed.
Item 2. After 2 weeks.
The Lordship, I beg to mention item number 4. The Lalit Council is out of station for some urgent work. Kindly adjourn the matter for today.
CD?
Not received.
Yes.
Earlier also perhaps adjourned. Earlier also it is adjourned.
CD not received.
Perhaps not called for, my lord. Because earlier it was adjourned and fixed on 25/6, my lord. File, my lord. But
CD is not called for, then we can call for the CD. 46 to lady. Yes, next. Wait for a while.
May I please, Lordship, I beg to mention item number 50, Lordship, 50, Lordship.
50.
Not received, Lordship. I am not on in time, Lordship. Kindly.
Where from is this?
Alugati, sir, Lordship.
Kolkata.
that will be on, my lord, 10th, my lord. 7, my lord.
Already.
May it please, Your Lordship. Lordship, I beg to mention item number 59, my lord. My lord, in this case, on last occasion, Amicus was appointed, but her name is not reflected in the causes, my lord. Kindly fix it on day after tomorrow by reflecting the name of Miss M.K. Brown, my lord.
59
59.
is the matter on, so showing the name of Brown as amicus. Date
Day after tomorrow, my lord. 29, if possible, 29. Please.
40. Going on like this. Call for the CD. 6.
May I proceed? My lord, 483 bail application, my lord. In this case, my lord, one co-accused has already granted bail, my lord. The ground in this case taken, my lord, the accused was produced, my lord, beyond 24, my lord, violation of 58 BNSS, my lord. And one of the co-accused already granted bail, my lord, on the same ground, my lord.
Where is that order?
Yes, my lord. I have annexed all the documents, my lord. Both the accused arrested on the same date, same time, my lord. Hmm? No, sir. No, notice. PNBN. 48, 50. Beyond.
Yes, PP, but
Lordship,
same footing.
8, my lord. Take the my lord because I'm of a motion, my lord. I pray for the CD for short date, my lord.
No. Both were arrested on the same date. We can give you some time to go through the petition if you like,
Lordship,
as well as this order passed by the court.
Lordship,
But all the documents are available here.
Lordship.
When it is violation is staring us in the face, we can't wait for.
Lordship. After some time,
Yes.
Hello.
May I please, your lordship, of commercial quantity, your lordship, 600, fire is at page number 11. Seized around 670.
Commercial.
Commercial, yes.
CD.
okay. Mistake of sir. Commercial.
Deeply obliged.
Lordship, it is of bail application under section 483 of BNS,
Commercial,
not intermediate.
how many days?
In 6. Around, my lord, 40 days.
83 days.
50 days.
Lordship, the lady is also 5 months pregnant, so Lordship, short date may be given, Lordship.
সোনকালে দিব দেৰি হৈ যাব 7 days
Obliged, Lordship.
mandatory period.
Lordship, the petitioner is charged under section 4 of POCSO Act. The notice may be issued to respondent number 2.
ADN notice to respond, no.
Yeah, please, Lordship. So this is my lord, regular bail application. Petitioner is behind the bar. Petitioner is a leading my lord. He is behind the bar last 40 days almost, my lord. 47, my lord, the offense is under my lord immoral trafficking act. My lord, there is a my lord, some my lord procedural my lord lapse, my lord. As per section 13 of the my lord act, my lord, arrest and search should be my lord by a person, my lord, special police officer. This is not done by the special police officer. This is my technical, my lord. Kindly see, my lord, forwarding, my lord. Forwarding report, Lordship will find it, my lord, page number 24. Sub Inspector, my lord, he is a professional, Lordship. And the mandate of the act is, my lord, should be done by a special police officer. 24, my lord. He is a professional. Moreover, my lord, at page number, my lord, arrest memo, page number 26, Lordship will find, Lordship, page number 26, last part, my lord. SI, one of duty Sunil, who is a.
Let's go to the FIR first.
Lordship. FIR is, my lord, page number 22, my lord.
Huh?
Page number 22. Page number.
What is 14?
Huh?
What is page 14?
14 is the my lord type copy, Lordship. Type copy, my lord. Anyway, my lord. I beg to inform you that on so and so at about 8 p.m. reliable information was received from Sanjay Kumar Singh, a prominent person of Bukamuk, through telephone number so and so that certain person were allegedly engaged in prostitution activity at Hotel Ili, situated at Gugamuk Sarile under jurisdiction of Gugamuk Police Station. It is further learned that said hotel premises were being used for soliciting customer and carrying on prostitution activity for monetary gain. Acting upon the said information, I, along with SIP, Sponokjyoti Sonowal, WPC Janmoni Pego, and so Gugamuk Police Station, after making a necessary general diary entry, proceeded to the said hotel for verification and necessary action. Under upon reaching the spot, a raid and search operation was conducted at the hotel. During the raid, in room number so and so, 2 women, namely Smriti Sondavati Gupta, that is the petitioner. Secondly, Sumsumi Soikia were found present. Only, they were apprehended on the spot. However, male person who were allegedly present in the room managed to flee from the scene, taking advantage of gathering crowd. During search and following articles were recovered seized from the room from the possession of the apprehended women in presence of the independent witness. This is the seized article. Further, a register book of the Hotel Lily was seized from the hotel in presence of the witness for the purpose of investigation. During preliminary inquiry, it was revealed that the woman, namely Sumsumi Soikia, wife of so and so, was allegedly being forced prostitution by the Sondavati Gupta, daughter of so and so. She was allegedly involved in the prostitution racket, was engaged in the procuring, carrying women to the various hotels for the purpose of prostitution. The information received and the fact revealed during the raid prima facie disclosed the commission of cognizable offense punishable under the relevant provision of the Immoral Trafficking Act and other applicable laws. The matter required thorough investigation to ascertain the identity of the all person involved, including the absconding person, the extent of the illegal activity being carried on, and role of the hotel management, if any, my lord. These are my lord allegation, my lord. My lord, second last paragraph, my lord, I've denied lordship. My lord, section 13 of the my lord act. Kindly, my lord, take up with this act, lordship. I did also.
How many days today?
My lord, 40 days. My lord, this is my lord offense, my lord, sexual offense, my lord, as per my lord, immoral trafficking act, my lord. This is my lord, clear act, my lord. Moreover, my lord, honorable. I have one judgment also, section 13. One more judgment, my lord. In the Supreme Court judge. This my lord, paragraph 13 kindly see my lord. Specifically says, Your Lordship.
That section,
Section 13, 14, 15 my lord, total violation was in this case. It should be done special police officer appointed by the my lord, state government. The person my lord, who is a probationer, just appoint.
Also, Mr. Probationers are the officers, they can act, my
No,
lord.
my
But regarding that, my lord, I have to consider. If it is probationer, there is no illegality.
And special police officer should be my lord, rank of, not below rank of inspector. 14 is there. Should be my lord, above rank of inspectors. Kindly see them, I submitted on decision of the Honorable Apex Court. This is clearly headless. Complete code deal with the offenses. Paragraph 13, my lord, kindly see. Paragraph 13, 14, 15. Paragraph 13 says, it is clear from the various provisions of the Act.
that 13,
My lord, paragraph 13, Lordship. Of the-
1-3.
Yeah, 1-3, Lordship. Is clear. It's a complete code with respect to what is to be done under it.
So he has to be an authorized officer like NDPS,
One more
Authorized
judgment,
officer.
by relying of the Honorable Apex Court judge.
not below rank of SI in Assam.
This.
Yes, madam. Not below the rank of inspector.
Inspector.
Inspector, that is.
Here it is
Also,
inspector.
authorized or not, my lord. But I pray, my lord, let it be My lord, can it be fixed on, my lord, after a week, my, along with the CD, because CD speaks, my lord, if he is authorized, my lord, then
What is happened, my lord?
that
By
is,
relying,
that's the
my lord, by relying this, by judgment, my lord, or my lord, coordinate bench of this honorable court already granted bail, my lord, one second, my lord, prima facie, my lord, there is a, this is my lord, violation, my lord. So, my lord, I pay for, my lord, although I made a prima facie case for granting bail, my lord, I pay for not absolute bail, lordship. Lordship may grant bail, my lord, today as a interim bail, my lord. Lordship may examine the issue fixed after 1 week, my lord. She is a lady, lordship, 40 days already gone, lordship. So, my lord, interim bail may be granted. Lordship may examine the issue. If, my lord, found, she is a, my lord, special police officer.
In Assam, what is the? I'm sure that there will not be a separate police officer only to deal with. The existing police officer will be conferred with the power probably.
power for the
But
amendment is.
because there will. Who is the person? Who is this in this case? Who is this who has effected the arrest?
Lordship,
My lord,
my lord, by the
in the FIR, my lord, lordship, may kindly.
FIR is, my lord, lodged by some other police officer, SI Dipti Tamuli, lordship. But, my lord, the forwarding, my lord, at page number 24, SI Professor Pranabjyoti Sunwal of Gita Kamuk PS. Moreover, and there are some, my lord, case
So it says in the FIR, I along with SI Pranabjyoti Sonwal. So I means the informant.
informant.
Informant is Dipti Tamuli.
Dipti Tamuli. She is also, my
What
lord,
is the rank of Dipti Tamuli?
SI, lordship.
SI.
Yes. Even, my lord, assuming, my lord, she is
So even if she
No.
cannot be conferred the power, obviously.
Where is the, my lord?
Even if power is conferred on some officer.
Lordship. Therefore, my lord, the coordinate bench already held, lordship. That's everything, lordship.
I was trying to see whether even for the purpose of arrest that is required. But then in this Supreme Court judgment, it has been very specifically said, even the power of arrest is included therein.
Detection, what? Investigation, my lord, and seizure, my lord, it should be done a police officer or authorized by the person, lordship. There is, my lord, no authorization.
It says dealing with offences. Dealing with starts just from the stage of arrest itself.
Is okay.
My lord, lordship may examine the issue, lordship, I may be granted interim bail. If, my lord, found, my lord, as part of provision of the act,
And anyway, it's 40 days already.
40 days, lordship. He's a lady, my
The
lord.
point.
Otherwise, male person also let
What
him
is
go
the
some
materials
other-
and
female
because
person, some
this issue has cropped up,
priorities
my
there.
lord. This issue has cropped up, my lord, so lordship may decide on that issue also, my lord, because
Then, maybe done.
because
There was prima facie cases there, lordship. A certified copy
tension
also.
part, my lord, that is one part, my lord.
Coordinate bench judgment also clearly held, lordship. 10, 14, 15, 16.
You may kindly fix it for CD in a very short time, my lord. A week. Right.
Yeah, we can
Friday,
examine the issue,
Friday.
but
Friday, my lord.
I think prima facie is entitled to be released on interim bail at least. Especially having regard to the fact that the coordinate bench has already pronounced on the issue. I'd had run at counsel for the petitioner and an additional PP. There is an application under so and so. The allegation as per the FIR, in brief is that page 23. Para learned counsel for the petitioner submits that as per section 13 of the Moral Traffic within bracket Prevention Act. It is only a special police officer who is empowered to deal with any offences under the State Act, including the power to make arrests. This regard has also relied upon the decision of the Honorable Apex Court in Delhi Administration versus Ram Singh in 61 SCC Online SC 96. The coordinate bench of this court by order dated 20/07/2026 in bail application 1867 of 2026 has also granted bail to the petitioner therein in view of violation of the provisions of the State Act while effecting the arrest. Of learned additional PP submits that he would take instructions whether the whether any police officer or class of such officers have been conferred with powers under the Act. Full stop. Para. Call for the CD. And in the meantime, learned additional PP shall also obtain instructions. Full stop. Para. Having regard to the fact that the arrest was made by an officer below the rank of inspector, which is prima facie in violation of the provisions of the ITP Act, and also having regard to the fact that the petitioner is a lady and has already undergone 40 days of detention, it is directed that the petitioner shall be released on interim bail of rupees 50,000 with 2 securities of like amount to the satisfaction of the and so list again.
CGM Dhemali bhai. High levelers, deep levelers. Might please, Lord. In this case, my lord, when the matter was listed before your lordship, yesterday, my lord, instruction was called for, my lord, whether my lord charge sheet had been submitted or not, my lord. Today, my lord, 61 days in custody, my lord.
58 minus charge sheet submitted.
When?
It is on 23/7/26. Before time.
Then, my lord, I would like to, my lord, place my case on merit because, my lord, other accused has already been granted bail, my lord. So, lordship, may have a look at page 31, my lord, that is the FIR, my lord.
Charge sheet may be called for. Oh, Assam police person.
Everybody, place case number 33 of the offense only.
33.
Your name is?
Petitioner's name is, my lord, Abul Sheikh, my lord.
Huh?
Abul Sheikh.
Abul Sheikh.
Abul Sheikh, my lord. Initially, this case was rejected.
Who was given interim bail? Abdul Mintu. This last order 36/26.
36. My lord, regular bail was granted at page 47, my lord, to one Habibur.
No, in this case, what? You're Abdul Mintu.
I am for Abul Sheikh. This is it, my lord, and 1930, my lord, BA number?
No, 1344.
Sorry, my lord, my
1930.
Item 58 should be my lord
58.
193.
But 58 is 1344 here before me, but it is listed as something else.
My lord, it should be my
Double
lord
check.
1930, my lord, it should be my lord.
Is it?
For cause list, it is 190.
Yes, even per my cause list, but the file before me marked as item 58 is 1344.
Wrong.
It wasn't nine. Call up the next item. I find out before that.
Pleasure.
Next item to Matok. Please.
Please, your lordship. The 482 application lordship. Lordship, before going to the FIR, lordship, kindly see my date of birth, lordship. My date of birth is 30 as per page number 19 and page number 17, lordship. My date of birth is 31/12/2024. And my lord, as per FIR, this crime was committed by one Jamaluddin in the year 2001, lordship. Before my birth, lordship. Kindly see the FIR at page number 15, lordship. I have submitted documents of my father for renewal of the passport, lordship. But my father's passport misused by one Jamaluddin. He was arrested, my lord. He was inside the jail. And my lord, I'm nowhere involved in this case. Kindly protect me, my lord.
Now, what is your case? The crime was committed before you were born. Huh?
Yes. Because lordship, my date of birth is 31/12/2004. And this passport was prepared in the year 2001. Then, my lord, it was renewal in the
Just
year.
a moment. What is the difficulty in going through the FIR first? Just
My lord.
see.
May I read the FIR, lordship?
Hmm. So where from do you get the date of the passport?
My lord.
You say passport was prepared earlier. Where is the
It is
date?
mentioned in the FIR, lordship. It is mentioned.
Where?
My lord, it is mentioned in the FIR, lordship, that he has applied this accused person Jamaluddin used the passport, prepared the passport. It is in the page number 15, last paragraph, my lord. Jamaluddin examined during the inquiry and admitted that he had applied for the aforesaid passport in the year 2001 by using the identity of Abdul. My lord, it's wrongly Abdul Mazid with it will find in the page number 17 also. Mazid with the knowledge and consent of Abdul Mazid and had thereafter travel abroad using the passport. I'm the son of Abdul Mazid, my lord. My lord, kindly protect me all the documents.
Okay. Allegation is against you is forgery.
Forgery
Using-
not
using-
committed by one Jamaluddin, my lord. I have not committed it because
So what is the guarantee that this document showing your age is not a fake one?
I kindly see the page number 21 also. I have submitted this document in the name of my father, my lord. How can I know that Jamaluddin is using the passport in the name of my father, my lord? He's a young boy, age of 21 years, my lord. It's a crime committed before his birth, lordship. It's a way back to 25 years, Lordship. And all the documents seized, Jamaluddin was arrested, my lord, on 1/7/2026, Lordship. He is inside the jail, my lord, who has used the passport in the name of my father, my lord. This affidavit submitted, my lord, because my grandfather name was wrongly mentioned, that is why, lords, in page number 21. Kindly protect, my lord, if anything will be there, lordship, may after the perusal of CD, may kindly allow me to appear before the investigating officer, my lord, for a limited period, my lord, just to cooperate with the investigating officer, my lord. It's a young boy, lordship, age of 21 years, lords. No? 20 years, my lord. 22, listen, 22 years. For a limited period, my lord. Because I have not used that passport, my lord, at all. It is allegation against Jamaluddin. Okay, it is for forwarding only.
Paragraph 4 of the FIR says, my lord, that he has used these documents in the verification process. ma'am.
That it was too long back,
No,
2001.
2001.
So even if his age is somewhat variable, that at that time he would have been too young.
But my lord, he has used that document for the benefit of himself, his benefit, my lord.
No, presently, this allegation is regarding the obtaining of passport by Jamaluddin by showing
Jamal,
the documents of
Jamaluddin,
Abdul
yes.
Majid. And
And
the
but-
allegation is that this fellow provided those documents to him.
This fellow provided,
But at that time, he would have been too young.
he had been too young, my lord.
Yes.
And that is, but here,
But now he has submitted the certificates of his own father. These are not 1, 2, 3, 4, 5. These are not fake documents.
yes,
But only that these documents were earlier submitted for obtaining passport in favor of Jamaluddin.
during the renewal process.
All right, heard learned counsel for the petition and learned additional PP application under so and so. The allegation says discernible from the FIR is that the present petitioner had provided the documents pertaining to his father Abdul Majid to his cousin Jamaluddin, who used those documents to obtain a passport and the said Jamaluddin fraudulently obtained the passport which he used to travel to Saudi Arabia. Full stop. Where a learned counsel for the petitioner submits that as per the FIR itself, the said Jamaluddin had applied for the passport during the year 2001 by using the identity documents of Abdul Majid. But the present petitioner was not even born at that time. So in support of our contention, learned counsel has referred to the Aadhaar card of the petitioner next to the instant bail application, as well as the voter ID card of the petitioner, both of which shows the date of birth of the petitioner as 31/12/2004. Full stop. where a learned additional PP submits that the CD of the case will be required.
The verification process, my lord, it was conducted on 14/10/2024, my lord. There he has submitted, my lord. My submission is there. my lord.
No, last line of FIR.
That's right. And the first line, first 4-5 lines, my lord.
These are the genuine document.
Was conducted on 14/10/2024.
That is on his application.
Yes, there he is.
We are referring to Jamaluddin's application. Puchilo,
Yes.
the CD will be required to verify the claims, full stop. Call for the CD. Prima facie, there appears to be force in the contention of learned counsel for the petitioner. Hence, it is directed that moment of his arrest, the petition shall be released on interim bail of rupees 2002 CRTs to the satisfaction of the arresting. Further directed that the petitioner shall appear before the IO in 10 days from today, along with all documents for the purpose of interrogation. List again.
I kindly record my submission and objection
Regarding
regarding that, my lord, that submission of the, because the, if I have not missed, here it is stated that during the verification process, Shaheen Ahmed submitted the following documents in support of the renewal.
that is correct. Those documents are not denied to be incorrect. Those documents pertain to his father, Abdul Majid. So he submitted those documents to obtain his passport. So that is not the issue. But during verification, they found that those documents were earlier used by this Jamaluddin. And this, according to them, this fellow helped him.
Willingly, my lord, yes.
Yes,
That is,
but
that is
that paragraph you were referring to, that is not the crux of the offense.
willingly, my. Yes.
It can be after some time, this likes in other court, man.
Wait, at 2, my lord, at 2. 4 o'clock.
Huh?
2, my lord.
2.
Publish.
Met with your worship. My lord, this case was earlier rejected by my lord Honorable Justice Thakuria, my lord.
2.
Since the earlier bench is not in session, my lord, there is an administrative order.
Yes, so charge sheet has been submitted.
Since charge sheet has been submitted, my lord, I would like to, my lord, place the case on merit, my lord. Page 31 is the, my lord, FIR, my lord. Page 31, my lord.
Been submitted, my lord. Now the case is beyond the FIR, my lord.
Let me send. Page 31, my lord. May I read the FIR, my lord.
What is the offense?
Offense is under, my lord, section 3032.
Are these any of these sessions tribal cases?
Lordship, my lord, sessions tribal sections are there, my lord, and moreover, my lord, another accused, my lord, Habibur Rahman, whose bail was rejected by this honorable court on the same date, my lord, along with the petitioner, my lord. And said Habibur Rahman, my lord, subsequently filed an application before the learned sessions court, my lord, and his bail was granted, my lord. And moreover, my lord, Habibur Rahman was, my lord, arrested subsequent to the petitioner, my lord. And as on date, my lord, I am 61 days custody, my lord, and some other accused are already in bail, my lord. So at this stage, my lord, if I permitted to, my lord, place my case on merit, my lord.
Who has been granted bail?
Lordship, my lord, page 47, my lord. The petitioner was also not, my lord, named in the FIR, my lord, page 47, my lord, kindly have a look, and may I forward this order, my lord, the rejection order of the Habibur Rahman, my lord, which was subsequently granted bail by the Learned Sessions Court. And his bail was rejected along with the petition on the same date, my lord.
No, but High Court rejected your bail application, is it?
Fortunately, that Habibur Rahman bail was also rejected on the same date, my lord. I forwarded a copy.
No, this order is page 35. This is you,
Lordship, my lord.
Abul Sheikh.
Lordship, my lord. The bail of Habibur Rahman was also rejected, my lord, on the same date, my lord, by the same court, my lord.
So why should he grant you today?
Subsequently, my lord, page 47, kindly have a look, my lord, he filed an application to-
9-6, then again 24-6, what happened? That is another bail.
Lordship, my lord.
That is also rejected.
Lordship, my lord. Second bail petition was rejected only because of, my lord, it was, my lord, too early, my lord. After rejection of the first order, my lord, only after a week, my lord, I have filed this application, so, my lord, next bail was rejected, my lord. And on 24/6/2026, my lord, the bail of Habibur Rahman was also rejected by the same court, my lord.
Yes, so
After, my lord, Chair Habibur Rahman approached the Learned Sessions Court, my lord. That is the order, my lord, page 47, my lord. He was granted bail, my lord. And although some other accusers are also, my lord, granted bail, my lord, I have annexed another order is at page 44, my lord. Now, my lord, since, my lord, case has already been charge sheeted, my lord, my further detention is required, my lord.
no, this bail was granted because there nothing was found against you, that person. There is no mention of you here.
Earlier ground of rejection is same, my lord, by this honorable court, my lord.
Good.
So far, my lord, rejection of, my lord, Habibur Rahman is concerned, my lord.
Uh,
I have just now forwarded a order of this honorable court, my lord. Ground of rejection was, my lord, having found sufficient materials against said person, my lord. His bail was rejected.
It appears this order was not before the Sessions Court. There is no reference to it.
Probably, my lord, I was not an advocate of in that case, my lord.
So,
When then, my lord,
upshot of all this is that we can't grant you bail without looking at the CD. TCR.
May I prefer a short?
Once the High Court has given a finding that there is sufficient material against him in the CD, how can the session just say there is no material?
Lordship, my lord. Can I prefer a short date, my lord? Because, my lord, already 61 days, my lord, I am in detention. Moreover, my lord, charge sheet has been filed, my lord.
All right. You are a veteran in the business. Wait for some time.
Obliged.
Met, please, your lordship. Lordship, in this case, initially the trial court sentenced for 1 year, my lord. Thereafter, we have filed appeal before the Learned District Court, and Learned Session just reduced it to 6 months. Now, my lord, during the pendency of this revision petition, the victim, my lord, he entered into a compromise because both the appellate here, my lord, the petitioner is the daughter-in-law of the victim, my lord. Now they are living peacefully, my lord. In this regard, my lord asked me to show some authority, my lord. The judgment
Yes.
showing that, my lord, in the same cases, our High Court, my lord, passed many orders. I am so submitting, my lord, before the 2 orders, my lord, on the same footing. post-conviction compromise.
So you were first convicted by the trial court, which
Trial
was upheld by appellate court.
Not avail, it is
So slightly reduced.
reduced, partly allowed.
Yes. So now question is whether the revisional court can.
Yes, my lord, but our High Court held that it can, my lord. Otherwise, my lord, it was, my lord, here, my lord, the victim is the mother-in-law of the petitioner, my lord. He also executed an affidavit also. First, my lord may take the criminal revision petition number 342, Parijat Kakoti, my lord.
What is the offense here?
Offense, my lord, initially is charge was framed under 326. Subsequently, it is converted to
326 is not compoundable, is it?
324, my lord. Yeah, now 324.
Conviction under 324.
324.
So here have the parties come to some understanding?
Yes, my lord.
So say that first. So this is basically an application for compounding of the offense.
My lord, this is application for revision, but during the revision
It is
pending.
an application for revision. Any fool can say that. What is the purpose of the revision? Is it for compounding or not?
Yes, my lord. My lord, in Ranjit Bhuya, my lord, here also, my lord, paragraph 2, this revision petition, my lord. Exactly, my lord, in these cases, during the pendency of the revision, they entered into and settled the matter amicably.
So the law is already there. 326 is there. Subsection 6 is there. Revisional court can also compound the offense. So say that much, we're getting this case adjourned for day and day without properly submitting what is that you want. Where is have you filed any affidavit?
Yes, my lord. Additional affidavit is filed.
Page 29 to 30.
In the additional affidavit, my lord, page 31, from paragraph, my lord,
Is it on record?
it is on record, from paragraph 4, my lord.
Paragraph 4, second paragraph.
Where is the appellate order?
Appellate order, my lord, that is 23 of revision petition, my lord. That's from page 23. Paragraph in 13, my lord, the conviction or sentence was reduced, my lord. Paragraph, page 27, paragraph.
We had to see. Wrote 234 in your additional affidavit.
Some
Typographical
inadvertent
state of
mistake,
324.
324 is.
We see. P24 is not compoundable.
But my lord, in such cases, my lord, when my lord, the parties are settled, my lord, the very old man, my lord, the victim also.
Give legal submissions, please.
Again, my lord, no, my lord,
This Parijat Kotogiri is of no use.
my lord, in Parijat Kotoki, my lord, incident also took place, my lord, in 2014. I think.
Conviction was on respect of a compoundable offense.
But my lord, is a notification. Just now I have seen, my lord, the 25th amendment, my lord. It was before the 25th amendment, it was compoundable. And the notification to come into force of the 25th amendment was published on 31st December, 30 December 2009. So my here incident is prior to December 2009, my lord. Prior to December, 30 December 2009, it was compoundable.
Where is the notification?
My lord, right now I am not having, my lord.
Can you get a CRPC published before 2009?
I have searched, my lord, but due to shortage of some time, I could not get. But just before some time, I come to know, my lord. That I also made an effort, my lord, but could not get. But that information I gathered, my lord. Before the 30 notification, publication of notification, 30 December 2009, it was compoundable. this case, my lord, Honorable Supreme Court also said, my lord, in such case, certain cases, although not compoundable, but sympathetic view can be taken up, my lord. I am also submitting before this judgment, but before my. Although here says, although not compoundable, but certain circumstances, you may be taken. When the offense, my lord, not so heinous, my lord, society, if not affected very badly, my lord.
All right. This decision, although it is a non-compoundable, Supreme Court has compounded, but your subsequent now submission is that at that time this offense itself was compoundable. So we have to pass an order based on facts. But if it is a compoundable offense at the relevant time, then the order will be different. If it is non-compoundable, then the order will be different.
My further submission,
So-
even if not compoundable, so some cases.
So that is what, even if we want to find out.
My lord, kindly take up the Ranjit Bhuya, my lord. In Ranjit Bhuya, my lord. Ranjit Bhuya. Here, my lord, paragraph
If
3.
the offense is was compoundable at that time, we don't want to say in our order that this is a non-compoundable offense.
But kindly
We
see,
should
my
be
lord,
correct on facts while passing an order.
my lord, in Ranjit Bhuya, my lord, paragraph 3, incident was 2/11/2024. 2014, 2014.
Yes.
Yet it was considered, my lord, the offense was 324 also. It is exactly similar, my lord. That also, my lord, may take into consideration.
That's okay. We'll keep this reserved. In the meantime, you get the notification and
Yes,
give it to us.
I get. But now, my lord, my further submission is, even if not compoundable, yet, my lord may consider, my lord, in terms of the Honorable Supreme Court judgment and our High Court's order judgment, my lord. Considering the sympathy, because both are, my lord, living very peacefully, old lady, my lord. They are in a same family, my lord. If the same is considered, my lord, no harm will caused to the society. It is not a heinous crime, my lord, like rape, my lord, murder. My humble submission.
We have all understood that. We are also inclined to allow your prayer. Only thing is, we need to be correct on facts and law while passing an order. An order of the High Court. It is a court of record. We don't want to say things that are not correct. All right. This is CAV. After
Yes, my
you
lord.
get
So
the
that, my lord, may be reduced to the sentence already she has undergone, my lord. She has undergone, I think, 1 month, my lord. She has
all right.
out of 6 months. I am deeply. One more thing. Yes, the probation of offenders at section 3 and 4 also not followed, my lord. That, my lord, may take into consideration. I am deep.
Go to this one. Madam, this petition is for quashing when FIR and charge sheet, madam. The law has given a small note, madam, that will make clear, madam. Handwritten, isn't it? Yeah. Husband and wife, madam, madam, I guess. Your lordship will find marriage 5/4/19. Your lordship got it, man. 5/4/19. Then the wife left on 2/2/21. But not returned, and she refused to return. Thereafter, her husband sent a pleader notice on 29/5, requesting to return. Reply given, she refused to return. This got some background, that's why I'm giving mother. Thereafter, mother, he sent another notice to come back, she did not. Then she filed, the notice was given for mother to Kaji, that mother, she wanted to give divorce. Then she refused, and ultimately, Kaji also registered that she, marriage was, divorce was given minor. Thereafter, this case was filed, saying that minor violation of section 4 of the present act, madam, act as an again. Yes, Act 19 Act. Is registered under section 4 of the Muslim Women Protection Act 2019. Just your lordship will find this here.
Yes.
This is the act, my lord.
Ah.
Section 4 can be said, section 4. Section 4, punishment for pronouncing talak. And talak means your lordship will find number 2C. This talak means talak biddat, my lord, meaning thereby in one sitting 3 talak. That is the talak in question here. Here it was given by the 3 month 3 notice.
first notice, then second notice, then third notice. Then when it was registered by Khaji. So this section is not at all applicable in the present case.
Talaki Bidat means talak in one sitting,
One sitting, in one sitting, three times.
3 times.
Yes.
Yes.
It is also, the book also I have brought
So
one.
talaki Bidat has been outlawed.
Yes. In my case, your worship has seen, my lord, 3 notice, 3 times notice given pleading notice, is not instant, my lord. This is the case, man.
Where is the FIR?
Yes. This talaka Bidat meanings, but a mullah from mullahs, my lord, given. Meaning. Yes. FIR is page 18. Page 181. 24, 622.
Yes. So in the FIR, it is admitted that the notices were
Yes.
sent on 3 occasions.
He admitted. He admitted, the officer said, and finally, you are page 19. Finally, dated on 24th, he sent me the notice for final talak. This pronounced talak is an arbitrary manner. This is the case. It cannot be, my lord, here. This act, the present act 19 act is not applicable in my case, man. In the present case. In the book, you will also find page 261. Kinds of Yemen. Talak Hasan,
Third para.
then 3. Number 3, Talak Bidat.
So the notices, 3 notices were not during a single tour, is it?
No. After 1 month, my first notice 6, 10, 21, then 18, 11, 21, then 24, 1, 22, final one. Then Qazi registered on 18, 7, 22.
So what has happened now? All are, both are apart. You
Yes.
have married again.
This is both are separate.
You have married again.
Yes. I have also not married anyone, my lord.
Huh?
Both are single, but he is also staying in the house. I am there, my lord.
Yes.
My lord, so far as my senior colleague has addressed on the section or act under which it was registered is incorrect, I concede. Section 4 is not applicable. It is absolutely not applicable. Because the way the police authorities perceived the situation would not be there. But now we are faced with a situation where the contents of the Ejahar are not denied. But the registration by the police authorities under an erroneous, wrong, whatever, is under question. To that, I would concede it is wrong. May I read the Ejahar once again, my lord? I'm only on the prima facie whether it throws up an offense or not. Over. May I read my note? Sir, most respectfully, I beg to state that I was married to one Iftikhar Hussain, son of Muhammad Imtiaz Ali, resident of house number 91 Hatigaon, Bhetapara Road, PONPS Hatigaon, Kamrup Metropolitan Assam pin code so and so on 5/4/19. Date would have a relevance, my lord. 5/4/19. And out of a marriage wedlock, a female child was born, now aged about 2.5 years. After my marriage, my husband and in-laws tortured me without any valid reason and wanted to divorce me. But I did not give any consent to that. So my husband, due to instigation of his parents and his sister, and in a pre-planned manner, brought me to my paternal house at Baihata Chariali on 2/2/21 and asked me to stay there for some days. And since then, I have been staying there along with my minor daughter. However, I have tried to settle the matter amicably, but went in vain as he did not cooperate. My father also sent a notice to the village headman Gauhati on 6/8/21 for compromise and to take me back further conjugal life, but they ignored the notice. Later on, Iftikhar Hussain, due to instigation of his parents and other family members, sends me a notice of talaq through office of the Sadar Qazi Dispur, Gauhati on 6/10/21, and subsequently on dated 18/11/21, the second notice was sent pronouncing second talaq. On both dates, I wanted to go there for my appearance. He threatened me of dire consequences. And finally, on 24/1/22, he sent me the notice of final talaq, thereby pronouncing triple talaq in an arbitrary manner. And that triple talaq is a cognizable offense now. Therefore, your request to take legal action against the concerned Qazi, the witnesses, and my husband, Iftikhar Hussain, along with his parents and sister. Registration under Section 4 would be bad. Now, for a moment, Lordship, the scope of investigation. May I just address on that? Prima facie, it is not against the husband per se, the Qazi, the witness, the family members, everyone. In this petition, two things have been stated, which my lord would find. Firstly, at page 7, paragraph 10. This is the sheet anchor of the entire submission. May I read, page 7, paragraph 10.
Yes.
That the petitioner begs to state that the Muslim Marriage and Divorce Registrar Dispur is competent for registration of divorce, and accordingly notices of talaq were sent through Muslim Marriage and Divorce Registrar Dispur to respond number 2 for divorce as a respondent is reluctant to continue. That would find at Annexure 9. Lordship finds that at page 63, 64 is the order. Their approach to jurisdictional registrar is based on their understanding that he is competent, and on that they're relying on a judgment by this honorable court, which Lordship finds at 64. May I read that? Paragraph 3 would be enough. 3 onwards, it's a very small one.
Yes.
Paragraph 3 onwards. That's a different person though. The grievance of the petitioner arises from the fact that the petitioner had submitted an application before the Registrar of Muslim Marriage and Divorce, Sadar Qazi, Government of Assam, Kamrup Metro, under Section 9 of the Assam Muslim Marriages and Divorces Registration Act 1935 for registration of divorce, talaq, from his wife, Bunwara Begum. The said application was submitted on 7/1/2020. The petitioner contends that in spite of such application being made after divorce from his wife, the registrar has not registered the said divorce and being aggrieved has approached the court. The court is of the view that if an applicant makes an application either for divorce or for marriage, the Registrar of Muslim Marriage of Divorce, who is competent to register the same, has to perform his function and duties and cannot sleep over the matter. Accordingly, the present petition is allowed by directing the respondent number 3, the Registrar of Muslim Marriage and Divorce, Sadar Qazi, Government of Assam, Kamrup Metropolitan, to do the needful for registration of divorce in accordance with law on the basis of the application submitted by the petitioner on 7/1/10 without any undue delay, as expeditious as possible, preferably within 2 months from the date of receipt of a certified copy of the order. By this order, Section 9, the power of and the jurisdiction of the jurisdictional Qazi was recognized. Now, if I may hand over, Lordship, the Act of 1935 for a moment. It stems out from Section 9. These are the scope of investigation. I'm only on that film. Section 9. Internal page 3, Section 9.
Yes.
Mayor, on application being made to a Muslim registrar for registration under this Act of a marriage or divorce within 1 month of marriage or divorce being effected and not otherwise, and on payment to a fee, I am on that. There is a precondition of 1 month. Therefore, the date of marriage herein would be quite relevant for investigation. The investigation would reveal 5/4/19, it is admitted. If 5/4/19 is the marriage and within 1 month you have not approached the jurisdictional registrar under the Act of 1935, the Qazi had nothing to do, and therefore my allegation against the Qazi stands fortified. This is the scope of investigation. It cannot be nullified because it was registered under Section 4. Of course, Section 4 was wrong. Second part, they have taken another paragraph, page 9, paragraph 12. Qazi would go on the 1 month count. So the entire make-believe story of divorce or talaq would go. Now we come to second page 9, paragraph 12.
Yes.
When I consider that Section 4 is not applicable because talaq biddat is there, it is my senior colleague's case or the client's case that page 9, paragraph 12, it is there is talaq-e-ahsan. He says it's talaq-e-ahsan. Page 9, paragraph 12. Of the forms of talaq, we know talaq ila kula liya ziyan mubarak. We are confined to talaq hasan, ahsan, and bidai biddat. So we'll address as the law unfolds after the Sharia Bano case. Page 9, paragraph 12.
Yes.
Mary, the petitioner begs to state that Section 4 of the Muslim Women Protection of Rights of Marriage Act 19 is not attracted against the petitioner. Correct. In the instant case, as talaq ahsan pronounced by the petitioner upon his wife is not instantaneous in nature. Whether the alleged form of communication of talaq was at all talaq ahsan. To appreciate that, I invite my notes attention to the Sharia Bano case 2017-9 SCC. We're giving a list of books below. Done 17-9 SCC. We have given the list of books. All for my lord's convenience, may I just read?
Are we here now to decide whether it is talaki ahsan?
We are only whether the investigation scope is there.
You have considered it's not talaki bidat. So Section 4 is not attracted.
It is also.
You have
correct.
considered Section 4 is not attracted. So now
Whether
tell us what
investigation
offense
is
is attracted, that is all.
Everything else is attracted. 4 is not attracted. I concede on that.
Now, what is attracted?
Yes. So far as the
What criminal offense is attracted? That is what we are concerned with.
Setting a talaq, but it's not talaq in the eye of law.
What?
We say torture. We have stated about that. We have alleged that. We have alleged against everyone. We said, if I may read, my marriage and my husband-in-law tortured me without the valid reason.
Okay, we will go to that. Apart from the torture part, you were taking us elsewhere. That is why we are asking you. Yes.
And Qazi, the witness and my husband. The Qazi exercised jurisdiction were not there in law. He thrown off my marriage on a purported understanding of this 35. He has to be taken.
So what criminal offense is attracted by that?
Why not? If everyone does things contrary to law, mere registration under the wrong head, prima facie when there are materials on record.
No, on the contrary to what law? Show us that what provision of the IPC or any other penal law has been violated by any one of the accused persons.
It need not be IPC, Milov. It need not be IPC.
No, you tell us what.
What I am on is that
His contention is that the FIR does not disclose any offense.
No, it
period.
discloses. I am on that, it discloses.
So,
I am on that, it discloses.
so
When
the
I-
apart from the torture part, what other offense is disclosed? Is there any other offense disclosed?
The entire procedure in which the talaq is granted, Milord, the entire exercise jurisdiction by the Qazi, this would be a subject matter of investigation. We have also implicated him. True, had it been only the husband alone, then okay, section 4 is not implicated, other things may come in on the torture part and all. Now we have implicated everyone. Only that the investigation to follow on that. And then there will be a charge sheet, and then there will be a charge. Every time they can consider that the investigation meets scuttled off only on that wrong.
Because it is precisely for this purpose. We are not here for fishing expeditions. That
True, Milord. So far as
investigation-
section 4, if a police wrongly registers an act, Milord, which prima facie shows that there is an element,
No, so you tell us whether the contents of the FIR disclose any other offense. You have to name that offense.
we'll come back, Milord. Watching may have it tomorrow, Milord. We'll come back with a specific offense on that. I was on that everything under the act was flouted by the persons we allege against them. Only the police registered wrongly. We'll go to specific provisions of Mohammedan law where offense are affected, Milord. Tomorrow, Milord. We'll come to that. But apparently the Qazi exercised a jurisdiction which was not there. Even the triple talaq mode, it was done. It is not there. It is not a case of talaq.
These are all matters of civil consequence.
Understand, Milord. But it is also a matter of investigation. Prima facie.
No,
I
we
am
can't
only on
subject people to investigation on the basis of civil wrongs.
Tomorrow, Lordship may have it. I'll give the sections. Lordship may have it tomorrow.
Will that be enough for you?
He'll get it tomorrow. Else, he goes, not matter. It's only on the penal consequences I have to address. I will address them.
What, tomorrow?
Tomorrow at 2 man.
Hmm?
Tomorrow at 2 man.
We can't give a specific time.
Otherwise,
We can give a date at best,
Any day.
not a time.
otherwise Friday,
Yes.
Day after then.
Day after. Obliged.
You can take back your book for now, I think.
Your lordship,
No, this will get lost somewhere. You place it tomorrow on the next date again.
we have
Or
given
you
the-
give a copy, a photocopy of that
Yes,
along with the
photocopy, this one,
publication.
Mullah. Photocopy has given man 1 page.
Conducting counsel, Mr. P. Bodole, emergency lordship.
Hmm?
Medical emergency of his wife lordship. Only list after 1 week lordship.
What is this? Item 11.
Yes, lordship.
Yes, what do you want?
Lordship, after 1 week,
Is it counsel for the petitioner also out of session?
All right. The prayer of both the sides, list the matter again on use. Date, give a date.
10 hours.
Lordship, please. This is a quashing petition, my lord. This quashing was filed in terms of a settlement that happened between the parties. Now, we have already adhered to the terms and conditions. An amount of 11.5 crores has already been paid. So it was in that discussion that this quashing petition was filed. They have raised an objection, my lord. May I take your lordships to the settlement, my lord? That's at page 124, annexure 2.
If there is a settlement, what is the dispute about now?
Yes, my lord.
Is
The
it-
dispute was in regards to creation of two
No,
companies.
no, yeah, you say you have entered into a settlement, but
Yes.
they're not adhering to it.
No, we have already paid the amount of 11.25 crores, which
Oh.
was a part of the settlement. And in terms of the settlement, we have filed this petition. It was agreed in the settlement that we'll file the petition and quash these proceedings. That's how I am here before your lordships. And that is already mentioned in the settlement also.
We have the CD, the adjournment lordship today. We have the CD lordship in this case, but we need adjournment lordship. We have not gone through the.
Anything to do in the state?
Otherwise, CD is there lordship available.
I think, my lord, there's nothing with dispute.
So who is for
Otherwise,
R2?
The parties are.
Amounts already being paid.
Who is for R2?
He's appearing. He's raised an objection.
You're
also.
opposing.
Yes.
You're opposing.
Yes, lord. I'm for the informant also.
Page one. Page
But
one.
then if state also wants to jump into the fray,
In our
then
role
how
to
much
play
time
here.
do you need?
They are okay with that lordship. Otherwise, CD is available with us,
Uh,
but we have not gone through the CD lordship. They need any assistance from the CD, I don't. What is there in the CD?
how long is this going to take otherwise?
Not too long. It won't take too long. My lord, we'll just come to page 130 for a minute. That's the settlement agreement that we've annexed. It'll be all clear, my lord. It won't take too long. 130. The agreement starts at page 124. That's the settlement deed that happened between the parties in regards to the same dispute. And your lordships will be kind enough to come to page 130.
Yes.
Yes, my lord. That is number 5. Against the receipt of the aforesaid amount, the first party, from the first party, the second party agrees and undertake to extend all cooperation for the first party for quashing of the FIR. And in terms of that, we have now filed this FIR. Now, my lord, 7, it is also agreed that in case the first party can pay the aforesaid amount consideration prior to time in one mention in the present settlement agreement, the same shall be equitably accepted by the second party, which they have accepted. As such, all necessary consequences arising out of the full and final payment of the agreed terms, same shall be with the benefit of the first party, and they shall have the liberty immediately to file a quashing subject to the FIR. Needless to say, irrespective of the receipt of the entire consideration of the settlement amount agreement, the first party shall be at liberty to initiate the appropriate proceedings in order to seek protection from the cohesive in relation to the subject FIR, including but not limited to seeking the stay on the same. So we've done whatever it is. The amount that has been paid, my lord, is at page 129, just before that. That is how the amount stands paid till 130, number F. So the entire consideration now stands paid. Whatever was agreed. And page 131, my lord. 131, clause number 8, my lord. That it is also unconditionally and unequivocally agreed between the parties that the first party shall not be responsible for any liability, statutory or otherwise, insofar as the third and fourth party are concerned, because there are 2 other parties involved. It has been unconditionally and unequivocally undertaken by the second party that he shall, and at individual capacity or the director or the third of us, shall satisfy all the liabilities, statutory and otherwise, to the third and fourth party. So if there is anything that cures that arises within that period, also now stands settled, and there will be no claim of the third or fourth party also. So in terms of my respectful submission, everything is taken care of. But the objection has come because they are saying that there was a statutory liability which arose within that period, which now in terms of this also stands settled. So everything has been paid. Para 9, my lord. Third line. It is further agreed and confirmed and declared by and between the parties herein that the second party shall be solely responsible and liable to pay all the statutory and other duties, interest, penalty, losses, liabilities, outstanding salaries, etc., which may occur while discharging the liabilities of third and fourth party. So even if it is their liability. That doesn't count under these.
So they are the second party.
Yes, they are the second party. So that also they have agreed for it. So the objection is the fact that there were certain liabilities that arises. Could be. There could have been arises, but that should have been taken care then. And they signed the agreement in those terms. So my submission is that, my lord, that's all been paid. Everything has been agreed. And we have come to court only on these agreements terms.
Yes.
Now, my lord, the objections that they have filed. The objections that they have filed, 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 they have fil Page 146, my lord.
Yes.
Para 4, my lord. There are 4 lines from the bottom, my lord, from the top. As per the email sent by petition number 5, I'm reading page 146, para 4. I think this is the last paragraph, my lord, 4th line from the top, from the top. As per the email sent by the petition number 5, basic GST liability was to the tune of 3 crore something with interest and penalty. This was also the basis of the consent terms subsequently signed between the parties on 15th of Feb 2024. It is understood that the part of the amount received by the deponent would be defraying the GST liability, and amount of so-and-so was taken into consideration for the agreed settlement as a partly sum of rupees 11.25 under the settlement terms on 15/2/2024. But to the utter shock and surprise, the deponent, the GST authorities have now raised a demand of 18 something, which came to the knowledge of the deponent on and after 2024, when the deponent received the series of notice from the GST department. So now they are saying that there is a period, in that period, where there were certain statutory liabilities that arose, which was not taken care in this agreement, which has been settled. Whereas the agreement says that everything that requires will be his responsibility that arises subsequent to the payment, which I have done, 11.25 crores. Yeah, and this is the year 2022. If your lordships will see the copy of the email which is annexed on that same paragraph, is 25/2/2022. And our settlement deed is 15/2/2024. So this is their objection, my lord, by saying that there's a term money which is existing. These are GST liabilities, statutory liabilities, which occurred within that period, which should have been incurred but not done in the agreement, not taken into consideration in the agreement. And in the same company where this liability comes, the director is also the second respondent who signed this is also a director in the same company. In fact, he's the sole director, I think, in fact. My submission that I have already paid the amount, whatever was agreed. And in terms of the settlement, I have come forward, I filed the quashing petition. All terms and conditions were agreed.
Let's come to the agreement once more. What is the starting
Yes,
page?
madam. I'll just come back to the agreement once again.
Just want to know who the
That's
parties are.
the clause in regards to this, which I read out,
No,
madam,
not
is
that.
that.
I just want to know who is who.
Yes, madam. I'll take, just the first page. 124. So he's Sachin Adhikari, wife, Monishka Adhikari, the daughter, and Mitali Sachin Adhikari, they're the other daughters, the 2 daughters, along with Amit Tipnis, who's the informant, my lord, the second party. And BWW Global is the company, which is the third entity, and Brit Wall Worldwide is the 4th party, my lord. And in both the companies, my lord,
So this petitioner is this Sachin Adhikari.
Sachin Adhikari, yes, who's come forward for the settlement.
Okay, and
Along with his wife and 2
respondent
daughters.
respondent is who?
Respondent is the Amit Tipnis, my lord, second party, at page 126. And if your lordships will see at BWD Global, it says he's represented through his director. So he's a director of the company, as well as the company which is below, which is Brit Worldwide India Private Limited. He's also a director there. So these are 3rd and 4th companies.
Before us, it's only this first party.
Yes, because
and
the
second party.
Yes, the FIR was against them.
Respondent one is only second party.
Yes.
3rd and 4th are not before us.
They are not. They are company manner represented by him. So in the settlement they have signed. Yeah,
What is your connection to the company?
I'm advising them, as that is mentioned as my lord at 126, the last paragraph. that Mr. Sachin Adhikari is an entrepreneur working in the field of developing and implementing human transformation models for building leadership and also helping others to imbibe the business values and ethics. So I was advising them. And the next page, my lord, 127, Sachin Adhikari, second paragraph, my lord, is 99% shareholder of Vistar International Private, a company registered separately, my lord, in Mumbai. And I was advising them on these two companies.
So who is supposed to be aware of the additional GST liability of 18 odd crores?
Second party, my lord, with all due respect, because they are the directors of the company.
Yes.
And at page 128 is the amount, my lord, which has been agreed to be paid. Number 2. In view of the to compensate the second party for a claim of the FIR, the first party hereby records, confirms, and undertakes to the second party will receive a total sum of 11 crores 25 by way of full and final settlement to the second party, and the first party shall out of their own assets and properties and his family members shall pay the amount of so and so. So this is what has been paid by me.
Yes. That is all?
Yes.
If you are no way connected with the two companies, lordship, ultimately why you have agreed to pay all this amount to me, lordship? So far as the business of these two companies are concerned, if you are not at all connected, then why you have agreed to pay me 11 crore rupees, lordship? That is the first question. Lordship, my basic allegation in the FIR was, he is my distant mama, lordship. I mean, he is my family, connection. I have some family connection with him. And he incorporated two companies, lordship, wherein I was made director. I was never involved in the running of the company. I never invested any money in that company. But as I was the director, lordship, I became liable so far as these two companies are concerned, lordship. Accordingly, I filed an FIR. I never took any decision. I never spent any money. So I am not at all liable so far as the liabilities of these two companies are concerned. And ultimately, he succumbed. He accepted the fact that, yes, he is liable. That is why he entered into an agreement with me, agreeing that, yes, I am ready to pay you 11 crore. And in that 11 crore, lordship, one component was GST. And it was his information to me, as I am not privy to the records of the company. He informed me that GST liabilities is around 3 crore. Subsequently, I became aware that no, it is actually 18 crore. So he cannot say that now you are liable to this additional, 15 crore. So that is my first case, lordship. So this is an agreement between me and him only, lordship. Case was registered by the state. So it is not automatic that just because one agreement was signed, it is automatic that the FIR will be quashed. This is nowhere, that is not the fact. At best, an agreement will reduce the punishment. Nothing more than that. That is the law, lordship. So today, lordship, what I am submitting, lordship, as they are saying that they are not prepared with the case, lordship, let them, also have their say, lordship. Let them be granted some time, lordship. Let them have their submission, lordship. Lordship would hear this matter ultimately and decide.
Has the state decided on a stand? Are you taking a stand this way or that way?
They have already investigated the matter in ways, just because one direction has been passed by your lordship not to take any coercive action. Probably that is why it has stalled. So lordship will allow the investigation to go at this stage. In the meantime, lordship will hear. Otherwise, they have accepted. The mere signing of this agreement itself reflects that they have accepted all the liabilities. In this case, only they, misinformed us that the GST liability is only around 3 crore. And one most important thing is concerned that GST liability, it is the, entitlement of the state, Lordship. If investigation is not allowed to go, how it will come out, Lordship, whose liability it is, that is one. And how much is the liability to the state?
And that is for the GST authorities.
GST has already issued notice, Lordship.
Yes.
Now GST has issued notice to me.
So on record, who will be liable to pay?
Me. On record, it's me. But they have accepted that it is their liability by signing this agreement. They have already accepted that it is around 3 crore. Now it is coming out that it is 18 crore. Now, if you have accepted 3 crore, why you will not accept another additional 15 crore?
But what about that clause in the agreement that was pointed out by your learned friend?
Lordship, in the
regarding
Lordship,
your liability to pay.
yes. So liability, exact liability is not shown there. But it is the understanding there in the affidavit. I have stated that at the time when this agreement was entered into, it was around 3 crore, as they have informed us. So I was
All right,
never.
when do you want to submit?
With all due respect, my learned friend has said, did not go back to the FIR, my lord, because I was presuming that the matter is settled in terms of the settlement. Would your lordships be kind enough, 2 minutes, your lordships will kind enough to see the FIR once. Just the FIR. Why did I pay 11.25 is the question that has been raised before your lordships. Why? The allegation is that I have misappropriated funds. Would your lordships come to page 23, 22nd of 9? This is the FIR that was mentioned, the complaint. Would your lordships see the name of the informant?
Yes.
It says, Amit Tipnis, please see the address, Navi Mumbai. Would your lordships go back to the name of the accused below?
Yes.
It says Sachin Adhikari, Nerul, Mumbai. Shashikant Tagre, Mumbai. Kiran Katman, Mumbai. The offenses are at next page. Nothing happens here. You come from Bombay, file a case against me saying that I'm your relative mama, put me in jail here. My wife has to take a bill. My daughters have to take a bill. And now you say the liability, the admitted of 3 crores liability was admitted because the admission was there at that point of time. 2.5 crores was agreed because you put me through a torture for last so many days. Investigation to go on, my lord, after the payment of 11.25 crores with all due respect. What is the point? Then why did you settle the amount? At that point of time, my lord, 11.25, I agreed for 3 crores because that was the liability. Subsequently, whatever rights could be right. I'm not saying it is may not be there. But would you again go back and say that, no, there is an investigation required after getting 11.25 crores? Is it fair enough to say that, my lord? Investigation is required. You could have done it. Nothing happens. You agree to take the 11.25 crores. Liability can exist, my lord. I'm not saying there could be liability existing. But the question is, you've agreed in the agreement that you will take care of the liability. I was alleged, the investigation is still not complete, alleged for misappropriation of funds, alleged. It was to happen and it had continued. But then a settlement happened. You have signed equally with this. You should not have also agreed for 11.2. If your demand is 300 crores, you should have sat down on it. Why did you agree for 11.25 when your allegation is more than 300 crores? You should not have come forward, my lord. I would have not come forward. Out of all the torture I would have gone, I would have to go to jail again, I would have gone. But this is not the conduct, my lord, after taking that amount. That is my submission. Today to say that, no, reopen the investigation again. It's a never-ending issue, my lord. You have a liability, take care of it in terms of your agreement. You can come back and file 10 cases against me, my lord. I'm not asking that. But in terms of this settlement, how will they go beyond this, my lord? That is my only respectful submission. Today the state comes and says that, no, we need some time to investigate. What? I leave that to your lordships, my lord, but it's...
No, not investigate. I think his submission is,
Yeah,
he
his
just wants to
submissions,
go
my
through the
lord,
CD and make his submission.
Yes, you please take care of the investigation again. There's a stay by this court. Terms of this settlement, my
I
lord.
want to point out that his submission is that he is not involved with it, he is not operating the director. He is the director, but he is not doing anything, lordship. I have to look into it whether he is doing this or not.
Who's the director?
No, he is the director, but he has not performing his duties. He has not invested anything. That need to be investigated, whether it is correct or not, lordship. It is, I have to go through. Otherwise, how can I say that, lordship? He is submitting something, my learned friend is something, submitting something. I have to.
So you're the umpire now.
Lordship.
All right. You go to the CD and tell us whatever is there. Let us have it from all angles. When?
On 4th of August.
Just 4th of August, my lord.
ইমান দিনেতো ৰাখিয়ে আছে ন 17 পৰা 18 লৈকে কিবা আছিলে
Can it be, my lord, if on the 12th or 13th, if it is not equal?
Any date.
In the week, Lordship, starting from 17 to 21st, Lordship.
Yeah, I mean, if it is 22nd, then my lord, if it's not inconvenience.
28 করে দিলেও problem.
20th no, yes, 20th is fine, man.
20.
20th is fine. Extremely good.
Obliged, Lordship.
Maybe not. CD is already there. Third, Mr. Learned Counsel for the petition. Also learned counsel for it to edit. Take some time to go through the CD.
Then we need to retain the CD, lord.
Yes, retain the CD. Again on. Get delay.
20, no?
Yes.
May it please your lordship. My lord, here order dated 9/6/2026. Pursuant to that, my lord, we have filed an IA assailing, my lord, the search sheet and the order of
9/6 or 19/6?
19/6/2026. 19/6.
Yes, so you have filed additional
Yes, my
affidavit.
lord. Yesterday, we have filed an IA with serial number 6610/2026, assailing both the search sheet and the order of cognizance. My lord, here I would just like to point out, my lord, stay of this honorable court was on 16/12/2025. Thereafter, my lord, from the records, my lord, it reveals 19/1, my lord, the search sheet was seen by the learned trial court. That probably my IA is not before lordship, so that may be, my lord. Because after the stay order, my lord, 19/1, the search sheet has been seen and taken on record. And thereafter, my lord, cognizance was taken. So that part is there, my lord. So let this IA be tagged along with this criminal petition, my lord. We'll be able to bring everything on record. We have put to challenge, my lord, both the search sheet and the order of cognizance. Later on, my lord, it was stayed, but before that, these two orders have been passed.
It is submitted on behalf of the.
Yeah, it is not on the record, the IA application. I have received a copy, but originally it is not recorded.
That is what he has submitted. Yes.
So the actually
submitted
IA
by-
is redundant here. The charge sheet is
Counsel for the petitioner that IA has been filed.
The outcome, the FIR. So
Being
it
a
is
challenge to
redundant.
the
So in spite of that, we
charge
file
sheet.
an objection. The case may be fixed on next week, Monday or Tuesday. File objections. Right, finally.
subsequent to filing of the present criminal petition.
Stay order is also impeccable because they after filing of the charge
But
sheet.
the same is
Stay
not
was
on
last
record.
minute.
Registry is directed to place the matter after placing the said IA on record. After tagging the said IA with the record. Learned counsel for the respondent submits that he has received a copy of the IA and would file an objection. Hence, list the matter again on.
My lord, interim order passed earlier
The
itself.
first to continue.
Actually, Tuesday, that.
25th. My lord, interim order may be
If it is
continued.
too long, my lord, is stays, then stay may be vacated, my lord, if the long that is passed, my lord.
And you said you'll file objection. Did you?
Objection file, next week, my lord, next Monday, or
20.
Tuesday, I'll file objection.
Huh? 14 Monday, 14, 13 on the hearing date, 13.
My lord, order dated 16/12 may be extended.
16 to. Order of interim stay stands extended till the next date of listing.
Obliged.
Here's some PP we were supposed to go through.
Control.
Who was there? We'll take up 2 then.
MP Goswami was there, Lord.
At 2 or if he comes before that.
Lordship, 14, 15 and 16 has been gone through by Kamal Lordship, Kamal Korakhar, and he is code number 1. So kindly pass over the for time being, Lord. He has gone through this 14, 15 and 16.
Can be tomorrow, my lord.
Hmm?
Item number 14. Item number 14, can it be taken on?
Why? If you have gone through, why tomorrow?
At 2 o'clock, another item is fixed, my lord, that's why.
You have gone through.
One.
Not one.
No, so
14, 15,
14,
16.
14, 15, 16, my lord, Mr. Parasar.
Parasar,
So let's do one. Just wait for a while. If since you are
Yes,
here,
ma'am.
we'll catch it.
one is there. Lord.
While you are still here, let's take care of this.
Regarding this case, my lord, earlier, this one, the law is clear, my lord. Earlier it was granted because the 24 hours since the detention part is taken into account, my lord. Here, one thing is taken into account, the medical report, my lord, that by 12:13 PM, the medical, since he was medically examined, so it could not be have been before 24 hours. Here, my lord, there is no medical report at this stage, my lord. That is what I am, so far I have found, my lord.
I have
So,
annexed
on
the
the
report,
base-
my lord. I have annexed the medical report.
Page?
Page 54, my lord.
P54.
Same time, my lord.
Only that part.
Naturally, it will be at the same time.
Yes.
They will not take them on 2 occasions. Where is the time mentioned? There, second last column.
Yes, my lord.
23, 126, 12:14 PM.
12:14 PM, that is.
So
10, 9:30.
Similarly,
same putting.
input.
It will pass orders.
Such.
Delivered.
My lord, scan copy was called for. It is a case under charge sheeted case under section 4 of the POCSO Act. The only thing is to be considered by your lordship, my lord. In the charge sheet is mentioned that medical report of the victim guard was received through DAC, and on perusal of the medical report, no recent sign of the sexual penetration is detected. in page 26. 142 days behind the bar, my lord. The allegation is that she was taken away forcibly to the house of the accused, and thereafter she was sent back. Police recovered her from the house next day, and this case was FIR law. In fact, there was a relation, my lord. Boy is of 23 years, girl is allegedly 16 years. After completion her exemption, she has gone to with the boy.
Trial has not started.
No, my lord.
You have gone through 183. The marvelous feat he has performed. He put her in the back of his bike, tied themselves in the rope, and then took her away. Huh? Special paper is not there.
High Court notification is there, my lord. I think it. Yes. They can conduct the case under IPC, not BNS.
What is IPC BNS?
That is the original from High Court, a government notification. The data to your lordship. IPC, not BNS.
They don't know how to read BNS.
And that is the notification stage matter.
Where is the birth certificate on record? As per medical, says above 18. What is the birth certificate? Is there? Huh? No, that is what is stated in, yes, some birth certificate is there. Imam Begum. Next date is fixed in September. Why such a long date?
Because there is no appointment of new advocate, my lord. That is the problem. They're waiting for the new appointment. Government will notify, appoint new advocate, then the trial to start, madam. How long I will be behind? 142 days already completed, madam.
Yes, anything to else to submit from the side of prosecution and respondent? Statement of the victim prima facie appears to be false as regards the manner in which she was taken. Inherently improbable. And your IO, while making the prayer for adding the section of POCSO Act, has stated that she has eloped.
She has eloped, yes.
IO himself says she eloped.
But immediately after examination, she has gone with the boy. It was not a forceful taken away.
Heard Mr. Biswas, learned counsel for the petitioner. Learned additional PP also heard Mr. Your amicus or amicus appearing on behalf of respondent number 2. This is an application number 2 and so. As per the FIR, the victim, girl aged about 16 years, went to her school for appearing in her examinations on 02/03/26, but did not return since then, and accordingly the FIR was lodged the same day at around 4:45 p.m. As per the para, it appears from the forward. Where is the forwarding report?
Forwarding report is made. Page 17, madam. Annexure 3.
As per the forwarding report, the victim was in a relationship with the petitioner, who is aged about what, 21 years?
Yes, 16 years.
Your petitioner?
23 years.
23 years. And upon promise of marriage, he had induced the minor girl to elope with him, and thereafter established physical relations with her. After that, he went to Bangalore and stopped communicating. The investigation has been completed and charge sheet has also been submitted and charges have also been framed under section 87, 64, 351, subsection 2, in bracket 2. And ANS read with section 4 of Act. Full stop. However, the trial could not commence till now due to absence of designated public prosecutor. The matter has now been fixed on, what is the next date? September 8th of September. So as of today, the petitioner has been behind bars for 142 days. 42 days. Upon perusal of the material on record, it appears to be a case of elopement. Pursuant to a love relationship. Having regard to the fact that case is now ready for trial, further of the petitioner necessary. Accordingly, the free for bail is allowed. 50,000 plus sureties. Petitioner shall not try to contact or intimidate the victim girl or her family members. Recording. Here is received, okay? Second para or third para somewhere. Yes. Which one?
In this case, this is POCSO case, this is complete police. So, amicus may
19.
19. POCSO the third time.
Service is complete.
So, amicus may
Learned counsel for the petitioner, learned additional PP submits that service in respect of respondent number 2 is complete, but none appears offense. So is appointed as respondent number 2. Copy of the petition be served upon the yes. Is the matter
next week.
Next week.
Diplomas.
Regarding visiting Bangalore, madam.
Huh?
এখানে আছে ওরা।
Orderটা বন্ধ reflect করছে না এটা?
23.
26.
Yes.
Is the fact of this 57 in para 16 cut copied and pasted from some.
But it is mentioned in the charge sheet. And that's why it was reflected in the bail rejection order.
See the charge sheet. Is it mentioned there? Huh?
It is giving two different facts.
Two different facts. That's why learned court, while rejecting the bail, has reflected this portion, my lord.
Some other complainant.
Yes,
One
this,
Sanjana,
that is what I, Sanjana Das, he is not the victim of the present
not
case.
the victim. But it is reflected in para 16.
We
In
have
charge sheet.
seen.
And during trial, it will have a different meaning in two cases. That indicates how Iowa was competently given the charge sheet.
Go to 17, item 17. There is one part regarding as per the forwarding report. Okay. As per the forwarding report, that have you got that? Forwarding report. Forwarding report, that part you cross out. Write again. As per the forwarding report in course of investigation, after recovery of the victim, it was found that the accused had kidnapped the victim girl and had taken her to a house where he committed sexual intercourse with her. Application had been filed by the IO seeking addition of Section 4 of the POCSO Act, wherein no, so, addition of section 87 stroke 351 to BNS. Read with section 4 of POCSO Act, wherein it has been stated that the victim girl had eloped with the accused. A perusal of the statement of the victim and the section be recorded before the magistrate, though indicates, though states that the victim was forcibly taken away. The same does not appear to be probable. Rest will be same.
Regular bail application matter under section 6 of POCSO Act matter. Arrested on 4/12/2025. It's almost 7-8 months.
In one case, we said amicus, no? Remove amicus has been given, no? Last two. Keep it blank will. Yes. Huh? Yes.
This is bail application matter under section 6 of POSCO Act matter. Arrested on 4/12/2025 matter. The gang rape is also there, my lord.
Trial not yet started. 3%. And it is floating at 9 months. And
Earlier rejected.
No, my lord.
no.
Recently charge sheeted method.
And substituted 1 to 26.
The story appears to be familiar. That is why I am asking whether it was.
I was not
This
the.
petition is on behalf of whom?
This is,
Huh?
the petitioner is Afirul Ali, the petitioner is Ariful Ali. But my lord, I am not the prime accused, my lord. I am being implicated, my lord. One, Mainul Haq, he is the husband of the victim girl, my lord.
That is Mainul Haq. Your
My-
name is?
My name is Ariful
Afirul Ali.
Afirul Ali. Afirul Ali.
Afirul Ali. So what is the connection of Afirul Ali? Oh, those three persons.
Yes.
Recording the evidence.
Mainul Haq and that victim girl was found in the paddy field, my lord. And then these three persons arrived at the scene, my lord. And we are being implicated, my lord. The FIR also it is said, my lord, it is try to attempt was there, my lord.
Hmm. These all three petitions are for the three persons.
I'm for the affidavit
Oh, these are other matters. This is 14 only.
14.
This heard learned counsel for the. We also heard learned Micah Curie for respondent number 2. This is an application under so and so. The allegation is that one Moinul Hawk had taken the victim girl to a paddy field and sexually assaulted her. When the unknown persons appeared, the said Moinul Hawk fled. Thereafter, the three persons committed gang rape upon the victim, who is a minor. The present petitioner is during investigation was found to be one of the perpetrators of the offense. The material available in the PCR, including the statement of the victim, has squarely implicated the present petitioner in the commission of gang rape. The trial of the case is yet to commence and the victim is yet to be examined. Para having regard to the above, the prayer for bail stands rejected. Petition stands dismissed.
Obliged, my lord.
May it please the lordship. Second bail application. The accused is charged with 103. It is behind the bars since 2010-2024. Today it is 646 days. Lordship may find the earlier rejection order at page number 51.
Page
51. Extra 5.
So what is the trial now?
Lordship, after that rejection, only one witness has come, and in the last 2 years, only 2 witnesses have been examined, Lordship.
Where is the TCR is here? Yes, pardon.
As far as the vital witnesses are concerned, the informant and the Gao Pradhan has already been examined. Rest are all hearsay witnesses and official witnesses.
You had yourself appeared before the police, it seems.
Lordship may kindly also appreciate that he has a 3-year-old son who is staying with the grandmother. And now he is living the life of an orphan because of the situation. Only prayer would be that Lordship may grant bail with strictest of conditions, Lordship.
They did not receive list again on interim. Yes.
Senior is coming, Mr. Followed for 5 minutes. Please, no, first minute. Space to Rasilam.
Very lordship, your lordship, the petitioner is in custody since 24/4/26. 3 months. In the case, in fact, your lordship will find from the first FIR which was filed by the present petitioner, page 32. And prior to the occurrence matter, this case was filed by the present petition, which is page 32, my lord. Thereafter, I'll take to your lordship the FIR against which I am seeking bail. Your lordship will find date 23/4/26.
Yes.
This is the my lord filed by the present petitioner, who is Mohavali. Your lordship kindly see, my lord. He is a plumber, my lord. They reside in the, my lord, in the same campus, and the son of the informant was under him, my lord, as a helper. He is working, and he was ousted from work. That's why this case is confirmed. This is your lordship file page 23. Next page, GD entry 23/4/26. Registered your lordship kindly say 9/5/26.
ZD is also 9/5/26.
No. GD entry your lordship kindly page 33, second paragraph. Same day. Same day, man. And present FIR your lordship will kindly see, my lord. That is page 12, man. Page 12. This is dated 24, but the next day. Page 24.
Page 24.
Page 20, page 12, man. Page 12. Is the FIR where we are seeking bail, man. Page 12. I have just shown because the background on that was 23. But this case was 24. And they are saying for last 4 months.
But down below, what?
Your lordship, for
It was
last
24/4.
yes, 24/4/26. And my case, which I filed 23/4. GD entry was 23/4. Registered subsequently, madam.
Registered after 1 month.
Yes, after 1 month. And preliminary inquiry, this 1 month cannot be, my lord, not at all required. And here you'll also find page 12, the allegation for last 4 months. Not a single, my lord, complaint, nothing at all. Only because, my lord, my statement is there, that the son of I am a plumber, my lord, by profession. And son of the informant was working under me as helper. For some reasons, I ousted him from the work. This is the reason, my lord, the whole thing has come by. Subsequently, it was get up. 4 months earlier, occurrence took place for last 4 months, my lord. And charge sheet also already filed, my lord. Further custody, I think, on charge sheet file on, your lordship will find page 22,526 charges were filed. And that is under section 9 of the POCSO. And your lordship, interestingly, your lordship, she also refused to go for medical test, man. Finally, have a look to page 24, man.
And
April,
1/8/26.
Yes.
This is 24.
Yes.
Type copy, and up line, below, all this, to 5 there.
it will only type. Honorable is there.
Page 17 is the type copy. 16.
5.
24/4. 17 receivable register on the same day, 24/4.
Yes.
And here cross case it was registered after 1 month. This present case is registered on the same day. 24/4.
Page 13 is the actual
Yes.
format.
13,
Format.
And page 16 is the
Page 14 below date is 24/4/26.
Yes.
and page,
That was wrong.
page 16 also.
Uh,
Page 16 also that types of
uh,
and now page 17 receivable register. 24/4.
yes.
So this is registered on the same day.
So our case is 23.
Yes, yes. The cross case is of 23, 1 day earlier, but the same was written after 1 month.
Oh, after 1 month, okay.
33 your worship.
Yes, 9/5/26.
9/5.
Oh, even if it is registered later on, the FIR was there.
Yes.
Now, in the present case, subsequently it is succeeded.
So what happened to the earlier case? They,
Present case is succeeded on 20 to 5. Within status, I have claimed in the.
it is fixed in August again.
Yes.
It is fixed in August
Yes.
for CC.
For CC, man.
For CC.
And on it, kindly peruse the one. We are implicated and. Very hard statement. Is not.
Only one line on page 24 bottom, finally, see, man. He refused to go, my lord, for medical test. Page 24, man. Charge Page 24, last paragraph, and bottom paragraph, middle portion, man. Page 24. Further, the minor witness guard was sent for medical examination, the treatment at GMCA, but she refused to undergo the medical examination. That is page 24, bottom one. And now we in custody, man, for about 3 months, 4 days, man. Keep it. I'm only on the further detention may not be required, man. The thing is, how POCSO will come, man. She refused to go for medical test.
Hmm?
She refused to go for medical test, man. She, page 24.
Is the CD also available? Victim state before the police?
Any report, anything, man, simply by saying will do, or something must be there, man. Only just to justify our FIR, man. They say the last 4 months. Opposite party also notice served, I think. Notice served.
Nobody for the victim?
Statement of who? Who is the statement? What is it?
Page 27.
Yes. Because she, in the police statement, she named him Mohar Ali. 183, she says, I don't know the name of the person who is there. Yes. You are amicus? Presenting. Yes. Commission. Mr. Chachuri Learned, Senior Counsel Learned. An application under so and so. The allegation is for the prosecution is that the accused person who was a neighbor of the informant committed sexual intercourse with her 10-year-old daughter since last 4 months by showing different types of temptations and also forcefully. There Grounded Senior Counsel appearing for the petitioner submits that incident had taken place between the informant and the petitioner as a pursuant to which the petitioner had himself lodged an FIR for the Odal Bakra OP on 23/4/2026, that is a day prior to the date of the alleged incident of the present FIR. Not alleged incident, date of the lodging of the present FIR. And the said FIR lodged by the petitioner was entered at Odal Bakra OP file GDE number 400 dated 23/4/2026. Subsequently, after preliminary investigation, it was registered as dispute PS case number 269 of 2026 dated 09/05/2026 under section 126 section 2/117 subsection 2 3512 S35 BNS. Further submitted that the present FIR is a counterblast to the aforesaid FIR lodged by the petitioner. Additional PP submits that the victim in her statement before the magistrate has implicated the petitioner. The TCR as called for has been received and perused, including the statement of the victim recorded by the police as well as by the magistrate. Here's that initially the victim had named the accused person before the police, but in her statement before the magistrate, she stated that she did not know the said name of the accused. Well, the investigation of the case is over, culminating in the charge sheet. And the case is now pending for consideration of charge. Where, having regard to the material available in the CR, well as the fact of completion of investigation and length of detention of the petitioner for about 94 days. Further detention of the petitioner may not be necessary according, therefore bail is allowed. $50,000 to securities. Condition where petitioner shall not try to contact the victim and or her family members. Treat them in any manner.
Right.
Allowed.
Additional
50,000.
special judge, my lord. Oh, so additional session judge. Also come with metro.
My lord, more only.
Yes.
My lord, with all respect, my lord. Disproportionate asset, my lord. Here, what has happened, my lord, in my understanding, my lord, no cash recovered, nothing of that sort, my lord. After retirement, he contested that this assembly elections, my lord. He lost. And thereafter, my lord, whatever be it, my lord, this case has come into existence. Of course, my lord, proceedings were there from before. And here, my lord, one section of law that was there in the Prevention of Corruption Act, my lord, 13(1)(e), possibly earlier act, my lord, with all respect, my lord. Therein, my lord, if the quantum of, my lord, disproportionate part, my lord, 10% or 20%, something was like that, my lord. That has now, of course, been omitted, my lord. Here, my lord, the crux of the matter, my lord, with all respect, my lord, may I come to the affair, my lord, with all respect and tolerance, my lord. Page 26 and 29 are important, my lord.
Page 26.
26, my lord. This is the affair, my lord. I'll be cryptic, my lord. Lordship may have found, my lord.
Yes.
First paragraph, last line, my lord. There is an inquiry beforehand. File CMS so-and-so 25. It began in 25. So-and-so, my lord. Initiated vigilance PS for regular inquiry. An inquiry, my lord, on a chartered accountant's report, my lord. Chartered accountant, my lord. With all respect, my lord, the disproportionate amount that has been found out, that is at page 29, my lord. Page 29, my lord. In properties, my lord, no case was recovered, nothing of that sort, my lord. Oh, not really, my lord, with all respect, my lord, 1 crore so-and-so, and he has a, my lord, family, my lord, small tree garden, my lord. We have annexed everything. All documents have been given also, my lord, in the name of my wife, my lord, son, and thereafter the disproportionate asset part is 34.54%, my lord. So this is the case, my lord. All we have appeared before the vigilant umpteen number of times, my lord. Rest is upon him, my lord. If arrest is not imminent, my lord, I leave it to your lordship, my lord. Case is also to Matana. Register officer, register officer to Matche. And he has retired from service, my lord.
Now, what is the stage of the case now? This is motion.
Motion, my lord. My lord, may I pray one thing, my lord? If you no coercive action to ever law.
Huh?
My lord, no coercive action, that line may be added, my lord. We fought election, my lord, Rondit. No, what I say. Heck, they live on, My lord, with all respect, my lord, that line only, my lord. No coercive action till it comes, my lord. And we have given all documents, and money is, my lord, no money was recovered from my house, my lord. Nothing of that sort, my lord. We have a 54 bigger small tea garden. Money is accrued from that. We have annexed all documents, my lord, and given to the department also, my lord.
Learned counsel. Learned counsel. Learned Mr. Kotoki, learned special public prosecutor. This petition has been referred seeking arrest bail in connection with so and so case. Hello. Vigilance PS case number 11 of 2026. Section so and so. The allegation against the petitioner is one of possessing disproportionate assets. This record query has been conducted and it has also appeared before the investigating authorities as submitted by learned counsel for the petitioner. Call for the case diary having regard to the circumstances as of today, provided that till the next date of listing, no coercive action shall be taken against the petitioner.
Highly obliged, my lords. Obliged.
Please take a note if it did.
Page, your lordship. Item number 20, 44, 44 and 60. 45 billing. Coming to that.
I'm not following what's happening. 20 then?
20, 44 and 60 I am appearing, madam.
Same affair.
Same affair, madam. 45 billing kodi.
Yes. So what is your submission? But same objection will not do. What is the allegation otherwise?
But allegation is against item number 60, my lord, Mintu Ali, my lord.
Caller bail, regular bail.
Mintu Ali is anticipatory bail, my lord, but he is already arrested in other. Now he is arrested, my lord. So this case has almost become infructuous in respect of Mintu Ali. In item number 60, there are two petitioners. Mintu Ali is already under detention, madam. He has been arrested. So, madam, in item number 60, madam, Mintu Ali's case has almost because infructuous because he is arrested in connection with another case.
You are on in item 20. You are on interim.
Yes, madam.
And in the others,
item 44 also, madam, regular interim is there, madam. And item 60 also interim was there, but I was arrested in another case, another different case. So now I'm in under detention, madam. And my allegation as per the FIR is against that Mintu Ali only, madam. Main allegations. It will only page for 22 now. Page 20, madam. Item number 20, the FIR, same FIR. 11 is the FIR, madam.
page 20.
Item number 20, page number 11. Allegation is against Abdul Mintu Ali, madam. Main allegations, madam.
Yes, PP.
I have. Where my lord, where my lord, where my lord took place. Person which is in my lord, that is.
Item number 60.
Item number 60, my lord,
Mutually.
he is also in interim. My lord. On the basis of the, my lord, that is the
Wife's in.
conditions of his wife, my lord. My lord. So my lord, that is also in my lord, Neha Begum is my lord, item number 45, my lord.
45
Who is
point.
also in my lord interim, my lord.
Item 45 more, no, I think the more.
20, 40 is also there. Huh?
No, no,
My lord, to tell my lord, my lord.
no, 45 more appear one.
My lord, 44.
44.
And my lord 60. All arising out of the same FIR, my lord.
Okay.
Item 45, I am not appearing, man.
Then
More appear one.
20, who is appearing? You.
20 I am appearing, 44 I am appearing, and 60 I am appearing. In item number 60, my lord. At this stage, my lord, regarding Mintu Ali, my lord.
Except 45, all are ABs.
No. 20 is also BA, my lord.
Huh?
20. 20.
20.
Oh.
20 is BA?
BA.
You granted interim?
Yes,
Well, okay.
So, my lord, item number 60, my lord. There are two petitioners, my lord, Mintu Ali and my lord. Rinku Ali, my lord. So, Mintu Ali, my lord, as he is already arrested in other different cases, my lord. So, we are not pressing his application as of now, my lord.
Yes.
If it has become he is now in jail, my lord. Now, anticipatory bail, what he will do, my lord. So, regarding others, we are pressing, my lord, and others, there is no specific allegation, my lord. Kindly see the FIR, item number 20, page 11, same FIR in all the cases.
Rinku is named.
But named, my lord, but Lordship may kindly see the allegation. But one Mintu Ali directly hit on my younger brother. But allegation is
As per the CDA, who was firing? Not all of them were firing.
Mintu Ali.
Here. That, my lord. Me is the person, my lord, who fired. Now, my lord, police, my lord. Or the weapon, my lord. At the. Get not because. One of the allegation is that, my lord, in item number. This is that. Firing from my lord, throat cancer. And in this regard also, my lord, in the bail application, my lord, police. So at that point of time, it suffered. But from that diagnosis, my lord, there is.
Later on.
My lord, material come out that my lord, see. My lord.
Report it. Item number 45 to me, no? What about report?
She was also present at the time of occurrence.
Yes, my lord. Because my lord, two parts of the FIR, my lord. If my lord may kindly peruse the FIR, may I read, my lord? Only my part of
Move to one,
FIR, my lord. My lord, is item number 20, my lord. My lord, 19.
No, 20, page 19. No, it's not for type copy this one. Page 404,
পেজ 11 আর 12
Type copy regarding. That is my lord. My lord, this is my lord, regarding my lord. Brother, read my lord. Yes, sir.
Yes.
Now, my lord, in the my lord, para, my lord, third paragraph, my lord. It is regarding my lord, other accused, my lords involved.
Neha and
Yes, my
Neha
lord.
Irfan.
Neha is the my lord, wife of my lord, that is.
So there again, allegation against them is beating.
Beating, my lord. And my learned friend is appearing from Neha, my lord. She was detected with cancer later on, my lord. Later on, no?
Yes. Your Lordship, whatever my learned PP is submitting, that is probably wrong because the order which we have annexed in the bail application in page 45, Your Lordship will find that on 25 2026, when she in item 45, Your Lordship, at which is at page number 31, she was bleeding from her mouth. Thereafter, the court said that you go to the AMCH. There, after diagnosis, the court said on 22/5/2026 that there is no serious ailment. Thereafter, the report which we have annexed, AMCH report on 23/5/2026, there it was found that there were multiple erosions in her stomach, and secondly, there is acute erosive enteral gastritis. So on that submission, the court had granted us interim bail. Now thereafter, diagnosis was made. Yes, on 27/6. That report probably Your Lordship will not find. I have a copy. That squamous cell carcinoma. This was detected. So she is suffering from skin cancer. Skin, stomach,
Metastatic.
The interim order that was passed on 11/6. On the basis of document that was annexed at page 36 in item number 45.
So from the bail objection also, the firearm was used by Mintu Ali.
Yes.
And Mintu Ali, we are not.
And you have him in custody.
Yes, my lord.
If you can't recover from him, whom from will you recover?
My lord, Mintu Ali is not in custody, he is on interim, my lord.
No,
He's
he's been
in now-
subsequently
now-
arrested.
Now he is in custody, my lord. Learned friend. Different case.
my lord.
No, but
There
different
is
case.
there, my lord.
My lord,
No. Different case means he allegedly again intimidated the petitioner, this victim side. And therefore he was arrested in
Yes,
and
madam.
another
Yes.
case was registered, he was arrested. So they are not pressing the interim for him. So
I mean, his interim may be vacated also, my lord, because he is in jail now, my lord. Regarding others, my lord, there are no specific allegations.
what I am saying is regarding this pistol, you have on the allegation of brandishing a pistol, you have arrested him. So if you can't recover the pistol from him, from whom will you recover the pistol?
Your Lordship, I want to bring one contradiction. In the FIR, your lordship will find the third para that so and so 5 Neha Begum, 6 Irfan Ali, all of them were beating this Adil Ali with hand and fist. However, if your lordship goes to the forwarding report, there your lordship will find the reason of arrest. That it is found that she was present near the place of occurrence. So both are distinctly different from each other.
In this Neha.
Neha. One is place of occurrence, and once they have stated that we were hitting with hands and fist.
Yes, and what is your objection you have filed? Where is it here? 60.
We are not pressing, my lord, item number 60 regarding mean to early.
So your objection is already there on record in one case. So you can make your submissions. No necessity of filing objections in every case. The same FIR.
FIR, but my lord, Abdul Mintu Ali, and he started firing with people. He mentioned manner and lifestyle.
According to you, all were firing.
Yes,
With one pistol, my lord.
so far, madam, they have much. The old type.
Yes.
Whereas this is a false statement. We have annexed Russian.
Item
85.
85. Item.
No, no, objection.
Item 60. What have you stated? By the time we find out, read.
Yes, madam, I have file of my objection, page 42, I have stated that with respect to the statement made in paragraph. He is one of right wrong. There is false one. The accused person names as mentioned in the FIR as accused number is Sinuali, son of Monwar Ali, and another accused number 3, Sinuali, alias Sina Ali, son of the Rajiv Ali, are the accused of the case, and they are very much alive and involved in this case. However, the petitioner annexed death certificate of another Sinuali, Idris Ali, makes some false ground to obtain federal orders from this Ali. I have annexed my lord,
Okay, anyway, that Sunwali is not before us.
Lord, may I submit one thing? They have named one SONO and SONU. SONU, death certificate is there. We have also annexed, my lord. He expired long back, my lord.
in the affair itself, they have one Sonu Ali. But actually, matlab, this is a clash between two families since long, matlab. That's why they didn't knew that who died, who did not. They have not stated the name of the father they have just once SONO in the first page and page 12 SONU. SONU has died, my lord. As SONU, my lord.
Okay. Okay, so no.
There are many cases of is almost both the accused person now. In the flooding also, which is
Again, Mintu Ali, my lord.
62. In my objection, to it,
Yes. 60.
yes, though it is only, but I have pending against other accused also now.
Will be on that merit. That is it. Or,
No entity.
Matlab, cases filed between these two families only, my lord. Between these two families only.
yes, next submission.
Person matter in the FIR.
So that is all. All right.
Regarding Mintu Ali, we are not pressing.
Yes.
But his brother, my lord, Rinku Ali, we are pressing. There are two petitioners in item number 60. Yes, my interim order may be vacated, my lord, in respect of Mintu Ali, my lord.
Yes.
Obliged, my lord. What, yeah?
Your Lordship, in item number 45, I'd like to submit the diagnosis report of Neha Begum.
May annex portion.
Original income.
For now.
Obliged, my lord.
Obliged.
21.
May I please, Your Lordship? Lordship, this is a regular bail application. And affair is at Lordship, case 14. And I am behind the bar since 14/6, and today, as on today, it is 45 days, Your Lordships.
Who are you?
Nomita.
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 You're the manager. So, what is your submission?
Lordships, here in this case, Your Lordships, although I have been mentioned as manager, but in that spa, I am not the manager. In fact, I am also a beautician. And that spa has totally been maintained and looked after by one, that is Anil Boro. He has already been detained and he is in also custody. And in the notice under 47, Lordships, he has been mentioned as the caretaker. And in the affair, he has been mentioned as the staff. But entire activities of the spa has been looked after and maintained and managed by this O'Neill Borough. And I was also working there as a beautician, and that was, it was the trade license of that spa was in the name of another person.
But this
that is-
Anil Boro is arrested.
He has already been arrested, Lordship.
And what about, what is the material against this Nomita?
The providing matter. So, get the tech. Kindly come to place the info. Clearly transferred to the sector. How much other going? Illegal prostitution.
And what about section 3? Special police.
That is.
Where is it said he is special police?
No.
Huh? He is inspector rank, but whether he is a special police officer under the act?
No.
If he is, he should say that in his description. Anyway, what is the period, custody period?
45 days as on today, Lordship.
45.
45 days.
Learned counsel. Huh? Materials are there, but then there is a cloud also under section 3, whether you are the special police officer. Learned counsel for the petitioner and learned additional PP. There is an application under so and so. The allegation is contained in the FIR revealed that a raid was carried out at SND Beauty Parlor SPA owned by one Sonmani Das alias Moon, situated at Durotiniali, Gauhati. On 13/6/2026, and in the course of such raid, which was conducted upon prior information, was found that a prostitution racket was being run in the said beauty parlor of several persons, including the present petitioner, who is described as the manager of the beauty parlor, were arrested. Para, it is submitted that the petitioner has wrong. It is submitted on behalf of the petitioner that she has wrongly been described as the manager of the beauty parlor, where she is actually working as a beautician, and that she has no role in the running of the prostitution racket as alleged. Where the CDS called for has been received and upon perusal, it is submitted by learned addition. There is material against the present petitioner. Full stop. Having regard to the nature of the allegations, a period of detention of 45 days. Further detention of the petitioner is not considered necessary. Accordingly, the prayer for bail is allowed. 20,000 to securities with the investigation. Satisfaction of
CGM Kamrup Metro.
don't say CGM Kamrup Metro, say Elaka Magistrate.
Elaka Magistrate, Lordship.
Gauhatir case bilakot Elaka Magistrate দিব পাৰে।
Deeply applied, Lordship.
কিমান আছিল আইটেম? লাষ্টটো কিমান আছিল? 20। Yes. You are for respondent? Learned counsel for the petitioner. PP. So and so your name? There's appearance for respondent number. We have filed a wakalat nama? We have filed wakalat nama? Yes. Place for time. But you want to file objection? File objection. Is the matter again on next week?
Charge matter, my lord. Scan copy of TCR was called for my. I see. Service to.
Respondent number 2.
We have taken a step through my public prosecutor office, my lord.
Hmm?
We have taken a step against the respondent number 2, my lord. Oh. PPO.
TCR is received. 10 copy of TCR is received, but notice on respondent number 2 is still awaited. Just again on.
My short date may be given. Already my lord 77 days in custody. Or my lord amicus will my.
1-4. In the meantime, you can take steps to concerned police station.
They have already taken my.
Again, okay. Get the instruction.
Step also.
And then you can get the instruction earlier also.
Yes, my lord. On earlier date, my lord.
Even earlier date then. All right, 10.
CD has been called for. FIR Lordship from page 17 Lordship.
This intermediate quantity. So the recovery was directly from you.
Lordship, can I, Lordship? Lordship, actually, Lordship, he is, Lordship, there is another co-accused, Lordship, Mustaqim, Lordship. Lordship, he is, petitioner is just 18 years old boy, Lordship. Lordship, Mustaqim asked him to come with him, Lordship. He is his cousin, Lordship. His only fault is that, Lordship, he came with him, Lordship. For just outing, Lordship, from his home, Lordship. His home is just near to, Lordship, Digeshwari temple, Lordship. Just 1 kilometer, Lordship. His cousin asked him to come along with him in his car, Lordship. For just an outing, Lordship. On that moment, Lordship, he has been arrested, Lordship. He has no knowledge only, Lordship, about everything, Lordship. The incident, Lordship. The 18-year-old boy, Lordship. The car also was not his, Lordship. Another person's car.
What is your name?
Lordship, Khorudhan Ali, Lordship.
Harudhan.
Yes, Lordship.
So as per the report, it was recovered from the other accused, Mustaqim. As per the FIR. Yes. No, if you see the FIR, just below, just above the recovery part, after complying with legal requirements, were recovered from the conscious possession of Mustaqim Ali, who wrapped this contrabands in his pocket. So nothing was recovered from the others.
17 years last statement of Mustaqim are actively
Statement of the accused only, Lordship.
in the car.
The car also was another person's, Lordship. That Mustaqim's car, Lordship. Lordship, Lordship, actually, they are neighbors, Lordship. Lordship, they are cousins, Lordship. The private car. Yes, Lordship, true, Lordship, private car, Lordship. That's why, Lordship, Mustaqim, when called petitioner, Lordship, he went with him, Lordship. But because 18-year-old boy, Lordship, in good faith, he went, Lordship. His future will be spoiled, Lordship. That's all, Lordship.
Your future is already gone.
9-7 minus
Lordship.
a month minus.
So Lordship, he is innocent, Lordship.
The age of 18 years.
Yes, Lordship. 18 years old boy, Lordship. He went with in good faith, Lordship. His cousin, Lordship. Only for Lordship, he is in the car, Lordship.
Learned counsel for the petitioner. Petitioner PP. An application under so and so.
Co-accused will say only, Lordship. Why he will, why he will go alone to jail, Lordship? Petitioner has no past any such record, Lordship.
So he was not even in the same car. He was on a different bike. Statement of co-accused. What to do? That is what the Supreme Court said. Even for anticipatory bail, it is no use. To us. We'll be happy. To us. One day's time. All right. List again tomorrow. Under prayer of learned additional PP, list the matter again tomorrow in order to enable him to submit certain decisions of the
Here also nothing has been found only from him, Lordship. Statement of the accused and co-accused, Lordship. Nothing has been found, Lordship. Nor anything has been found from his pocket, Lordship. Nothing has been found only, Lordship. Nothing has, he is not done only anything, Lordship. Totally innocent, 18-year-old boy, what he can do, Lordship? He just went with his cousin brother in good faith only, Lordship.
Yes, we have passed the order.
Lordship, tomorrow, Lordship. Yes, Lordship.
May I please, Your Lordship? Lordship, the up-to-date case diary was called for.
She did not receive list again on next.
Lordship, Lordship.
My lord, this is the application, my lord, for cancellation of the bail granted by the learned session court, my lord, and they have entered appearance today, my lord.
Yes, you
Without
learned counsel for the petitioner. Learned counsel has entered appearance for the respondent number 2. Please for time to file.
my lord, the case diary
Objection.
is received, that may be retained, my lord, and a short date.
Depends on the date. Why do you need 2 weeks?
Lord, affidavit.
Well, yes, PP. What will you do with the CD?
Item 30.
He has entered appearance for the, he is going to file objection. So. No, will you retain it? He is going to file objection. You'll retain.
Week's time is sufficient, you know, if we just file a short affidavit.
12th August. CD will be retained. Huh? But if you return the CD, then all right. CDB returned for resubmission in up-to-date form. Yes.
Obliged.
Please, Your Lordship, on the previous occasion, updated CD was called for.
Up-to-date CD not received. Interim order continue nil. List taken up.
My lord, this is the matter where TCR has been called, my lord, and
All right. Where is the affair?
my lord, here my submission is that they are daily wage laborers, my lord, and moreover, the case which has been arose is because of the reason of that, my lord. FIR is in page number 11, my lord. The reason was that there was Mehfil was going in through in a masjid, my lord. Hundreds, thousands of people who were gathered there, my lord, on that day. And my lord, accidentally someone has lost his mobile, and coincidentally, accused number 3, who is not the petitioner here in this case, he found that mobile. But the informant's son, he found the mobile. That was not like that he was stealing that mobile, my lord. It was just a coincidence, my lord. But the informant's son, he started making chaos out of that, no reason. He started shouting, he was started blaming me, means in a mahfil, a good weather condition, it was like that, but he was making everything in a bad way, my lord. And then, my lord, at evening time on the same day, my lord, we went there to discuss about this matter, my lord. But then, my lord, informants at morning, younger son has blamed us, and at evening time, my lord, informant's elder son, he was there. And when we called him that to settle it, let's settle it, the matter. So instead of that, my lord, they again started doing all this, my lord. So it's nothing like that stealing of mobile and like this, my lord. Whatever
What
they
about
have.
stealing of mobile? Allegation against you is firing and
Firing it, we have not done, my lord. We have not done, my lord, any firing. Moreover, we have to find out that whether medical report is there or not.
what is your name? We means Zahir Ahmed. You are Zahir Ahmed, aren't you?
Jahir Ahmed, yes, my lord. Jahir Ahmed and Samaduddin, they both are the
You are accused
petitioners here.
number 1.
Yes, 1 and 2. And number 3, Saharul Alam, he was the person, he got that mobile, my lord. And I want to know what is the medical report they are saying about, and whether that weapon has been found or not. If weapon is not found, and if it is not been said that who has that, if it is has been done, who did that? Because hundreds, thousands of people were there, my lord. That's why, my lord, I cannot take the blame on
100,000
myself.
people. That means 1 lakh.
No, my lord. Hundreds of people were there, my lord, because it was a mehfil, my lord. That's why, my lord.
Huh?
There, my lord, and he
My lord, finding of empty cartridges or these cartridges, that doesn't mean that I have fired. As there were lots of peoples, other peoples also.
Well,
And
any
at
statement,
morning, if he can,
any statement of eyewitness is there regarding them?
my lord,
Which
if
statement is that? Yeah, is it an eyewitness account or is it, was he present there? Can be hearsay also. That is what we want to know.
yes, my lord, and another, my lord. My lord, there was a simple fight that could be happen, my lord. But the pistol belongs to me. That is not, my lord. I'm simply a labor, my lord. I don't have that much of money to. Yeah, I am not at all involved in this, my lord. And regarding medical report, they are saying that it was a simple injury. Yes, we have also incurred that. In absence of concrete evidence, my lord, we cannot say that I have done that. I have not done.
Direct eyewitness account is not there. Hmm? But this didn't happen at the masjid at that time. Subsequent thing happened later on at night. So he was present in the, because the incident occurred later on.
I am not at all involved, my lord, in this.
Order dated 6/5/26.
Yes,
Hmm?
they can. Yes, informant's son has at morning done this. Informant's elder son has done that evening time.
But what is the complainant statement?
Oh.
About my
What is the statement of that victim whose head? He is not the victim. Uh, Pistol, he doesn't say. What?
A lot, if that being so, they are saying such a things that I have got done with rod, with pistol and this, that. My lord, they came to hospital and on very night they were being discharged by the hospital, my lord. If that being so serious, they would have admitted for at least 2 days, at least 2 days. It could go more also, but at least 2 days. On the same day, my lord, on the same night, they went there and after few hours, they were sent by the, they were not even admitted. It's not like that. And moreover, if they are saying that gun regarding, my lord, the this place, it is near to Bangladesh border, my lord. So founding of these things, cartridges or like this, it's not so like that I have done that. They don't have proof that I have done that. I have not done. Simply saying they can, at morning also they have saying that I have stole. Why I will stole? I will steal, my lord. There were a ceremony was going there at the masjid. Someone, it's a normal thing, my lord. One may a phone may be misplaced, my lord. And out of this, a simple thing, they have started making all these things, my lord. But I am not involved.
Who is the bailiff?
Arms Act offences are bailable. Arms Act. Any arm is recovered? No.
Absence of proof, my lord, I am not at all.
All right.
involved. Yes, we will face the trial, but I am not at all involved. If they have proof, I will also proof. SD Chaudhary, my lord.
Order dated 6/5/26. Okay. First, second, third para. Has been although scanned copy of it was called for the earlier date, on the previous date. It is submitted by learned PP that investigation is, the charge sheet has not been filed and instead has produced the CD. On perusal of the medical report, it appears that the injuries suffered by the victim are simple in nature. So there is allegation of firing with a pistol from a appears that no one was targeted, and therefore section 109 BNS may not be attracted. No pistol has been recovered either. Full stop. Para having regard to the above, the custodial interrogation of the petitioner may not be necessary. They have been, they are on interim, their statement recorded.
My lord, interim. My lord, the interim was being passed, my lord. But the thing is that from this honorable court, my lord, but the honorable court has said that in case of arrest, they will get bail from the. No, in interim order, it is like that. Order has been passed, but order has not been passed that I will appear before the arresting authority, my lord. That is the thing, my lord. That's why, my lord, I was not able to give all these things, my statements to investigating officer.
That is what we are asking. So I has not called him.
Yes, I has not called us. No, see, on 6/5/26, my lord, the Honorable High Court's order is there, my lord, 6/5/26, my lord. Honorable High Court on that day, on last
The
paragraph.
order of prior's bail is allowed. The order of interim is dated 6/5/26 is hereby made absolute on the same conditions.
My lord,
Yes. Yes, it's allowed. Yes, next case.
yes, my lord. Within 7 days, I will appear.
It's further directed that the petitioner shall appear before the IO within a period of 10 days from today. Interim, it is said they will appear before the IO as and when called, but here they have not been called.
Yes, they have not called us. They have never called us. Now we will appear within 10 days. Obliged, my lord. Highly obliged, my lord. Highly obliged.
So 36.
Yes.
May I please, your lordship? Lordship, petition on interim bail, lordship. Lordship, kindly have a look at the Azhar at page 23. There is the allegation that in respect of DAG number
Yes,
290.
CD is resubmitted, updated CD. There is, because there is a direction to record the statement.
First,
Lordship, allegation that there is a forgery of the signature of one Jumur Ali, Lordship. Lordship, kindly have a look at Lordship sailed it. At page, Lordship started from page 30. And signature of the vendor at page 33. Kulchum Bibi, Ahila Bewa. They are the vendors from whom Giyasuddin purchased the land. Tag number, Lordship, 39. Miadi Patta number 290. So there is no forgery. No case is made out that any forgery is committed. In respect of
Allegation is that you affixed one thumb impression of the deceased father.
Oh, not
of the
that.
inform-
Lordship, kindly have a look at whether I have affixed this signature of the Jumur Ali. That is not. Here sign is Kulchum Bibi and Ahila Bewa. They have signed.
Page?
Page 33. That's why I am saying. Seldid I have annexed. Page 33. It started from page Seldid started from page 30, Lordship. And
No, not on this, on some NOC.
Oh, no. Lordship.
Where
It
is
is
that
said-
NOC? NOC is there.
The case is that, Lordship, that petition number 3 and 4, they have stated that and 4, the petition, they want to dispose this, the informant lot from his landlord. However, 1 and 2 sold him to this same sold. They have stated landlord. However, if I look into the death certificate is there. One death certificate is there, Lordship. That is of 02/01/2008. He is on 2023, Lord.
Not from, I have not purchased, not from him.
No,
Not from Jumur Ali. Jumur Ali died in the year 2018.
NOC is also given, Lordship.
It is in the year 2023 and we have purchased from Kulchum Bibi, PT case number 1 and 2. Not from Jumur Ali.
For getting the land, Lordship, they have to, Jumur has to sold it to someone.
No. Not from. It is their ancestral, paternal land. I have annexed also Jamabandi. That is wrong. You kindly whether Seldid was seized by the IO or not. Kindly look at.
NOC, regarding the NOC, Lordship, it has been stated that NOC dated 19/1/2023 has been the one letter has been made under section 94 of CRPC, Lordship, whether this person has came or not. The notary has stated that 2 persons came to the and they have stated that this is a Jumuran. And his thumb impression has been given, but she has stated that she has not verified. She has not verified. One advocate has come and said that this is Jumur Ali and the other person is there. NOC, one asked for the original copy of the So the fingerprint can be. But here the.
Lordship, may I
First,
submit to?
let me submit, then you can submit. Very well submit. Then it is clearly stated that this has been online lordship. And, they have used the Seva app, Setu lordship, and from that they have uploaded this document. And the original is with this person's lordship. They are not cooperating. They have not given the original NOC. So it is pending on this line. Lordship. Moreover, lordship, it is because of that finger impression has not been. And NOC in the clearly it is stated that when no, as the notary person has stated that this is the Zoom impression. How it can be in 2020 case of for the make this document and this person, the present petitioner, if you look into the FIR, what he has stated, lordship, he has clearly stated that he has tried to dispose this person. How this come NOC regarding this NOC, lordship, is one of the questions arrived before this. Regarding this NOC, it is not explained. Because this Zumurali thumb impression is there. This is there in the NOC I have there. This is Zumurali. How we can put this thumb impression, lordship? Not the original one. It has been guessed from the notary, lordship. So original we have not found. It is dated also, lordship. Lordship, we can. Whole question regarding NOC also, lordship. Thumb impression is there, lordship.
This is dated 19/1/23.
23, lordship.
And when he died?
2018, lordship. Certificate, death certificate I have also there. They have given this NOC, the one, the letter is also there from the DC lordship. On the basis of this lordship, NOC, they have been given mutation, land has been muted to them.
Not on the basis of NOC. Lordship, no. Lordship, whether sale deed was seized by the IO or not. Your Lordship, kindly have a look at page 30.
Lordship, kindly.
On the basis of the NOC, how land can be mutated unless it is there is a valid transfer, Lordship. And there is a mutation, Lordship's NOC number is there at page 33. Lordship, kindly have a look at letter number, NOC number 2, number 322501, 2023. And the NOC given by the Deputy Commissioner.
Report is there, lordship. From the Deputy Commissioner, report is there. They kindly go through that, lordship.
Whether sale deed was forced or not. There are cases that by the fraudulently, Lordship, sale deed was executed. Whether it is a signature of the Jumurali in the sale deed or not, that is the issue, Lordship. In respect of DAG number, Lordship 290, Patta number 290 and DAG number 39, whether land is belongs to Jumurali or not, that is to be ascertained by the IO. The Lordship, and also the civil case is pending. If they have any grievance, that they can approach a civil court. We have Lordship already case registered, Lordship.
Forgery is the criminal case, lordship. There is a criminal angle also.
No, who are the petitioners? Are they related to this Jumurali?
No, lordship.
No, mutation can happen on the basis of an NOC, provided that the persons in whose favor the mutation is made, their names are already there as descendants or whatever, co-owners.
But the report is there.
The mutation can happen by either by way of inheritance or by way of sale or gift, something like that.
Sale deed, Lordship.
So if it is to be on the basis of an NOC, it has to be by way of inheritance. Say my brother has given NOC, I have no objection if land is mutated in his name. But if they are strangers, then how can their names be mutated on the basis of an NOC?
But it is reported in that report, it is stated on the basis of NOC. Lordship may kindly.
Absolutely a false case, Lordship. It is a purchased land and I have annexed all those documents.
What are the names of the petitioner?
Lordship Kulchum Bibi and the Lordship Ahila Bewa, Giyasuddin, Abdul Aziz. Abdul Aziz is no way connected. He's the son of petitioner number 3. No way connected. Falsely implicated him in the purchase of the land.
Yes, what do you want to point out from this?
And in the NOC, why did Lordship, the name of this dead person? Him also they have put was died on 2018. 23 in NOC.
NOC was used to obtain the land sale permission, it seems.
This is a forgery, Lordship. Yes, there is a forgery there, Lordship.
If he was dead, what is the need to obtain?
Lordship, that is not
NOC?
fair. I have purchased land from 1 and 2. Accused number petition number 3. Purchased from land from 1 and 2. And that is their inherited land. Whether NOC of the Jumurali is required or not. It is a totally false case, Lordship. Whether IO seized my sale deed. One aspect, whether my mutation is based on the Lordship NOC or not. Lordship, kindly have a look at the, I have annexed the mutation copy, Lordship. Jamabandi copy. Lordship, kindly have a look at page 35. Page 35. Land was mutated on the basis of the strength of the sale deed, not on the basis of the mutation as released by my learned friend. I have annexed page 35. That aspect was not investigated by the IO Lordship.
No, sale deed was executed on the basis of sale permission.
Lordship.
So sale
That's why-
permission was obtained on the basis of NOC.
Not by the, whether it is a NOC given by the Lordship, it is required by the Jumurali or not. It is a sale NOC given by the Lordship Deputy Commissioner, not from Jumurali.
Deputy Commissioner will give the permission,
Lordship.
not the NOC.
Lordship, The NOC, Lordship, why? Mural is NOC, why necessary, Lordship? It should be given by the seller, Lordship. Not from, I have purchased not from him. His signature, Lordship, that aspect, you may have seized my seal deed, Lordship.
Yes.
Whether that was seized or not. Jamabutti record, Lordship. That will reveal everything. Whether it is based on the NOC, land was mutated. It is based on the sale deed, Lordship, land was mutated.
All right, we'll examine. Yes.
All right.
Item 38.
Wait, please, Your Lord. The anticipatory bail application, the petitioner was granted interim, my lord. Thereafter, the petitioner appeared before the IO. 34.
All right, updated CD is not available. Send back the CD for resubmission in updated form. List again on so and so. Interim order passed earlier to continue. Next date of listing.
Deeply obliged.
Please. For application lordship, petition is the interim lordship. He appeared before the IO and his system also already recorded lordship. FIR is page 9 lordship. This is no question. Morning class. 39. He is already APL lordship and his statement already recorded lordship. He is a certificate holder register.
What is the allegation?
Only allegation is that in his when the house of the petitioner searched lordship, 11 number of cattle skin recover lordship. And he is a certificate holder that is page 17 lordship. As a dealer, retailer, businessman, Mubarak Ali beef shop lordship. He has a beef shop lordship. And according some skin and tools of the meat cutting for cutting of meat lordship, which is recovered at the in this case, in this connection to
All right, order dated 4/5/26. Era 1, 2, 3. Four. Additional PP submits that charge sheet has already been submitted. By CS number. Having regard to the nature of the allegations and the fact that the petitioner pursuant to interim protection granted by this court has appeared before the IO from IS submitted by learned counsel. There appears to be no necessity of taking the petitioner into custody for the purpose of facing the trial. Accordingly, the prayer for prayers bail is allowed. Order of 4/5/2026 is hereby made absolute.
Much of this.
May, please, your lordship.
The last petition Lordship has made inquiry, Lordship, whether any case is pending against this petitioner or not, Lordship. I have approached before this honorable court for anticipatory bail in connection
Any
with the
report?
Lordship Victoria PS case number.
Your nickname is Ambani. Says you have not appeared.
Lordship, what happened in this case, Lordship, last occasion, Lordship has made inquiry whether any case is pending against this petitioner or not, Lordship. This petitioner, Lordship, before this honorable court, Lordship, filing AB in 962, Lordship, for Vihupuria PS case number 53/2026, Lordship. That case, Lordship, his bail was rejected. That's why, Lordship, his apprehension of arrest. If he appear in this case, he will be put in jail, Lordship.
We are dealing with this case only. Even if I grant you bail, what will happen?
That why case against me, Lordship? Why case against me, Lordship, page 22, I have annexed order of this court, Lordship. Anything happened, Lordship, this that was the incident happened in the last year, Lordship. This year, Lordship, on March, Lordship. That order I have annexed, Lordship. Page 22, Lordship. Now, every time the police try to prosecute him as a criminal, Lordship.
Where is the FIR?
Here, FIR, Lordship, will find on page 15, Lordship. On page 18 is the certificate copy, Lordship.
Anyway, whatever the antecedents or whatever allegation is that fake gold was recovered.
He is not a fair.
Hmm?
He is not a fair name.
He is not FIR named, but even above, as far as the FIR named accused are concerned, what is the offense? What is the offense? Fake gold. By itself, what is the offense? Unless you were trying to sell it to
Yes,
pass it
no.
off at best, then cheating.
No victim has lodged in any FIR, Lordship. It's a
Oh.
police personal lordship.
You are saying it is fake gold. He is not claiming it is gold. Is it not? Order dated 13/5/26. There are 1, 2, 3. TDS call for has been received. IO has stated that the petitioner has not appeared before the IO as per direction of this court while granting interim protection. Of learned counsel for the petitioner submits that the petitioner indicated in another case being
Vipuria PS case number 53/26.
and his pre-arrest bail application connection with the said case has been rejected. Because of which he apprehends arrest. He appears before the IO connection with the present case. As it may, it appears the petitioner is not an FIR named accused, and even going by the contents of the FIR, not clear to what specific offense has been made out. Merely account of possession of some material which has been given the nomenclature of fake gold in the FIR. So having regard to the above, the prayer is bail is allowed. The order of interim bail dated 13/5/2026 is hereby absolute.
Highly obliged.
My pleasure, Lordship. Lordship, serious call for Lordship.
They did not receive. They did not receive. List again on so and so. Interim order passed earlier to continue.
21. Please,
Please, your Lordship.
The report was called from Dispur police station whether any FIR is pending against the petitioner. 42. Case pending as paper.
Report, my lord.
Additional PP submits that communication has been received from the OC Dispur PS that no case is registered against the present petitioner at Dispur police station. Petition of the OC Dispur PS be kept on record. Yes, dated 17/7/26. Petition stands closed accordingly.
Deeply obliged.
Wait, please, your Lordship. My lord, in this case, the petitioner is already in interim bail, my lord. What had happened in this case, the petitioner the informant alleges that in 2018, she was married and she is lodging this FIR in 2025, that is after 7 years. She is saying that her husband, Ramesh Gwala, married her forcefully when he was a child and there is a baby
of 5 years, whose age is 5 years, and the baby is with the husband. And that is the allegation, my lord, in short. Now, my lord, I am not for Ramesh Gwala. The entire FIR is against Ramesh Gwala, who happens to be the husband. Now, my lord, the present petitioner, along with 5 other petitioners who are either friends or relative of the husband, they have been implicated. My lord, may kindly come to page number 41. This is the order, page 41, 41, my lord. My lord, this is a classic case of the abuse of such, my lord, acts, my lord. My lord, we have seen what 498A has nowadays become. This POCSO is also turning out to be that. Page 41, my lord, will see these are the people already granted bail by this honorable court because their name figures out in the charge sheet, not in the FIR. My petitioner is also similarly situated. He is also on interim bail. In fact, my lord, this honorable court was about to enlarge him on absolute bail on the last occasion only because there was a miscommunication, because the amicus curiae which was appointed on the first date, Surojit Das, he in fact moved this petition and the court was not aware that he has moved this petition and made him as an amicus curiae, my lord. And on the subsequent date when it has came to the notice of the court that the court appointed some other amicus curiae who is there, my lord, today. Otherwise, my lord, that matter would have been the court was inclined to pass final order that day itself, only because of this amicus curiae. After 7 years of marriage, she is alleging her husband to have, my lord, forcefully married her while she was a minor and all these things, my lord. I'm not, anyways, my lord, I'm not holding the brief for the husband. As far as these people are concerned, they are the friends, associates of the husband. Certainly in the charge sheet, their names figure out, my lord, because she subsequently in a 164 statement has made a statement that while she was 6, 7 years old, they did bad acts with him. This is
His involvement is not clear from the FIR. There appears to be no. His name is not there.
very long. They even accept the husband, nobody's name figures out in the. Only because these people did not help her in getting back the child, so she implicated all of them at a subsequent stage. And I have already participated in the trial, my lord. My bail bond has been accepted by the trial court, learned trial court.
Anyway, there cannot be any allegation of POCSO against him.
Absolutely.
Since he is not named in the FIR. There may be some peripheral role.
He's against the husband.
But they have not been named in the FIR, have they? That the offense relates to which year? How long back?
It will be at least 15 years back, because in 2018 she was 13 years. So she will be 6-7 years in the 18 or 13 বছর হয় 11-12. And if we go by that, this petitioner would also have been a minor.
What is his present age?
42. And if I go by her 183, which she has deposed in 2025, saying that 2013, 7 years back, against husband and against them another 2011.
Heard order dated 26/6/20. Era 1, 2. Four. Your name is Amicus Curie? Huh? Dear Doctor, okay. The scanned copy of the TCR has received. It appears from the statement of the victim recorded under section 1 PRPC that she has indicated the present petitioner the commission of offences under section 376 IPC stroke section 6 POCSO Act. However, their names are conspicuous by their absence in the FIR lodged by the victim herself. Full stop. Further, the allegations relate back to a period that is about 14-15 years back, and having regard to the fact that investigation of the case is already over from the custodial interrogation of the petitioners. Or petitioner is not one petitioner.
Only one.
Necessary. Accordingly, the prayer for arrest bail is allowed. Order of interim arrest bail 26 hereby made available. The same terms and conditions. Absolute on the same terms.
I'm deeply obliged, man.
Success not available. Delete. Not available.
Second occasion. Did not received for the second time today. Is the matter again on quick?
Deeply obliged.
May I plead your lordship? Section 8 of POCSO lordship, FIR page 8 lordships, 7 lordship. Earlier occasion, CD was called for.
Yes. Yes, what is about the CD?
First of all, paragraph 5 of the bail application stated that there is some dispute between the informant and the accused during the land issue. But admittedly, my lord, there is no landed property of the informant which has with the accused land. False statement, absolutely. Secondly, my lord, paragraph 6 stated that petitioner was the Arabic teacher and victim was the student of his school like Mukta. But the right petitioner not an Arabic teacher, evidently. Khadim, it's an Arabic term, actually cleaner like cleaner of a masjid, but he is not a teacher of Arabic. On the fear of occurrence, my lord, true, my lord, it will reveal as well as 183 statement of the. However, another thing, my lord, I'd like to state here regarding this, again, this same petitioner. Some few years ago, my lord, same allegation also raised by the same locality, and that allegation, my lord, due to some intervention of the local people, like my lord, monetary transaction, settle that dispute outside the my lord, judicial purposes or my lord. Subsequently, he committed same offense, so I have serious objection. But on the other hand, as per my information, in her statement reported by magistrate under 183 JNSS. So, at this instance, this application that they revealed. That's my humble submission.
Offense is registered under what? Sexual assault.
5 years participation.
Point of time, my lord, as per her birth certificate, her date of birth, my lord, I'm not getting it one.
Material is there, but whether his custodial interrogation is necessary, that is the question. 5 years, are they required to comply with Anush Kumar or not?
Cooperate with the investigation, Lordship, as and when required. We face the trial, Lordship. No, Lordship. It is 50, 55 years old, Lordship.
That was compromised. That was the mistake.
This is also going to compromise, Lordship. In the affair, it is clearly mentioned it, Lordship. Page 7. Question number 1. As stated in the Azahar, the incident took place on 24/6/2026. But what is the reason for which you informed the matter before the police station on 27/06/2026? An answer: we are villagers, and as we expected that the public will provide বিচার, justice. As such, there is a delay in lodging the affair. The actual fact is that they have some demanding some in the time of visa. So there is, Lordship, a land dispute also between the long-standing land dispute also between the informant and the Lordship accused petitioner. So he is Khadim, but in absence of a Zunab, he was also teaching the girls sometime, but never. So, Lordship, my humble submission is that, Lordship, 5 years punishment, Lordship. I will cooperate with the investigation as and when required.
Let the police go under 35 if they require.
You call for from police whether it's actually land dispute is there or not. There is a clear false statement, madam. No land dispute is going on between. And I have no any landed property attached to it with him.
So, Lordship, I will give the opportunity to produce before the police concerned authority, Lordship. So I will be protected, Lordship.
Give a message to the society.
For that purpose, it has to be required as well.
So I have a
Heard
55
learned
years
counsel for the
old.
petitioner and learned additional.
Co-learner,
also
Brett
heard
Order.
Mr. Spencer learned counsel appearing for the respondent number 2. This is an application under so and so. Where the allegation as reflected in the FIR is that the petitioner had sexual assault upon the victim, who is aged only about 10 years old, by kissing her on her cheek and pressing her chest. Para counsel for the petitioner is a false case lodged on account of a prior land dispute. Moreover, the offense is punishable imprisonment for 5 years only. Therefore, his custodial interrogation may not be necessary. On the other hand, learned PP, with reference to the CD, has submitted that allegations against the petitioner stand substantiated by the statements of the victim recorded by the police as well as by the magistrate. Head counsel for the government also submits that there is no land dispute between the informant and the petitioner, who was also earlier involved in similar kind of acts. Para regard to the fact that the victim, a girl of tender years, court is not inclined to grant pre-arrest bail to the petitioner. However, this petition is disposed of with the observation that since the offense is punishable with imprisonment for less than 7 years, the police may proceed against the petitioner in terms of directions of the Honorable Apex Court in Ernest Kumar. And as per section 35 of the DNSS, petition stands disposed of accordingly.
Your Lordship, my lord. This is for quashing of the criminal proceeding. And on last 2 occasions, my lord, respondent were too short time for filing objection, but they could not file. My lord. Otherwise, my lord, the interim period, my lord, so far order dated 12/12/2025, passed by the Supreme Court. The LCR already received, my lord. So, my lord, interim period may be, my lord, allow, because FSL report doesn't say anything. So far, LCR report also there and closed. And my lord, LCR, my lord, trial court report, the FSL report, my lord, I have given the flag mark saying that the FSL report doesn't say anything regarding my forgery. and I have no any beneficiary regarding this construction, my lord. And construction already completed, and so far annexure 1 is concerned, previous video already given the letter regarding utilization of the construction. And now in our present video, my lord, lost the affair. Previous video saying that yes, so far release amount is concerned, that has been utilized. Annexure 1, that is page 16, my lord. This is, my lord, issued by respondent 3, and respondent 2 filed lost the affair. And the honorable court also granted pre-arrest bail.
Who is respondent number 3?
3, my lord, previous video, my lord.
Huh?
Previous video. He stated, he issued this letter saying that release amount already been utilized. But the present video lost the affair that I have collected this amount from the bank by using the signature of respondent number 3. And so far FSL report saying, yes, there is no any finding. And so far, my lord.
So there is no interim order.
No, and saying,
All
my
right,
lord,
all right,
page,
let's have it
page
next week
12,
then.
well, order dated 12/12/2025 saying that after receipt of the TCR, my lord, interim period shall be considered. And TCR also revealed the same fact what I have narrated in my in this petition, my lord.
If it is not.
Let me submit. Regarding the FSL report. FSL report, whatever I submitted and closed in my petition, and so far TCR is found identical, my lord. TCR, my lord, saying that I have given the flag mark, and FSL report saying that the case may be resubmitted. TCR, I have given the flag mark, and that is saying that the case may be resubmitted if sufficient amount of specimen writing, at least 5 pages, with some content as the question writing as well as some admittedly genuine writings of the concerned person are sent for comparison along with the question documents. But that has not been complied. And without going through this, the impugned charge is submitted. And charge sheet says another thing, my lord. This contention has not been revealed in the charge sheet. Therefore, I am before this honorable. And so far, my lord, annexure 1, the utilization certificate and letter, and the bail petition, my lord, seeing the identical, my lord, view, my lord. Page 23, my lord. As this on report, and here saying that release amount of rupees 5,48,184 already been utilized. And there is no any single whisper in the FIR that this amount has been misutilized. Nothing is there. Honestly, Lord, I am being harassed because of this affair, and I am not the beneficiary. I was the president of the construction committee, and the secretary was the construction committee head, and I was the nominal head, my lord. And from the secretary and other public, no any affair loss. And by agreed, this present video lost.
What is the stage of the case now?
Now, my lord, trial is going on, my lord. Trial is going on.
Evidence is going on.
Yes, lord. They are not appearing, these 2 videos are not appearing in the trial court. And I have unnecessarily, my lord, harassed because of this.
So when is the next date fixed?
Next date fixed, and my lord, the ECR, my lord, report saying, my lord. So, my lord, my humble submission, my lord, so far FSL report is concerned, and so far annexure 1 is concerned, utilization certificate, and FSL report is concerned that there is no finding. So, my lord, stay may be given, my lord, till next date, my lord. And also, there is a clear order by the Supreme Court that on 12/12/2025, that after receipt of the scan copy, the interim period shall be considered. Humble submission, my lord, still may be given, my lord.
Trial has not started, it seems.
And Lordship, page, my lord, 23, kindly have a look, my lord, of the bail petition. Page 23, para 8, clearly saying, after perusal of the record, TD, my lord, it reveals that 5,48,184 already been utilized out of this sanction amount. And this is the release amount. Release amount already been utilized. And there is no single whisper from the public regarding the construction of this college, my lord. Adani College of Institute. That has been well constructed. So unless this present widow lost this affair and already harassed, my lord, and I am not beneficiary of this scheme. Not beneficiary, then how question of forgery and cheating arise, my lord?
Yes.
That is the I'll not
Yes.
page 19.
Yes, yes.
So, that it has come to my attention. Member secretary of the for observation following subsequent check number, so it on examining this from the above mentioned, it can really looking all committee and the checkbook was taken for the and no office report was taken. Thereafter, people now
Yes, that we have already seen.
Yes. Happened there is that all the markings are not matched, but there are certain markings which have in a sense to enclose ratings and signatures stamped in similarly stamped in match to Q pair. But some of the markings have come as non-match. Say that this FSL is given, it is not correct. At this stage. And Lordship, even otherwise, there are ad hominem against the petition. That I have done this for pecuniary benefit. They're completely unsubstantiated. In my humble submission, Lordship, thing of the FSL report is not correct. It is not given in the
Lordship, may I submit, my lord? Super, my lord, allegation,
All I'm saying is-
allegation, me, my lord, regarding the signature of respondent number 3. He stated that already been utilized.
Fact remains that only two persons, president and member secretary,
Member
their
secretary, my
signatures
lord,
are
this is-
required.
Member secretary issued this certificate.
Yes.
This is member secretary lordship, this is BDU. He is the member secretary. Page 16. Our previous,
Allegation is that the signature of member secretary is forged.
but he said already been utilized. And he also paid that remaining amount, sanction amount lordship 7 lakh and 5 lakh something already released. Release amount already utilized. And he prayed in this letter that remaining amount is to be released. That is not done and contrary lost the affair. So this is the vital point, page 16, my lord. Taking into account this letter of previous video when the construction was going on. Previous video was the member secretary and I was the president. And member secretary has not alleged anything. Now when another video, present video come to the office, he lost the affair. And without and remaining amount has not been released. Therefore, I am saying for this his pecuniary benefit, he lost the affair intention and nothing else. And FSL report also failed to identify my signature, whether it is false or genuine. So, my lord, there is no case at all. Why unnecessary I am being harassed to face the trial, my lord? To face the trial, why I am being harassed?
It will allow me to confirm these statements and allegations that have been made against me.
My lord, my humble submission still may be given.
Should may fix a
Till-
date for hearing will file it.
It will pass orders.
I love this.
Yes. Yes.
With your lordship, no service report of the respondent number 2 has yet been received back.
Service report in respect of respondent number 2 not yet received. Wait, service. List again on.
This is for condonation of delay of 344 days. Lordship had appointed amicus for the informant. I'm appearing as a legal aid counsel.
This is what against
Against conviction.
is the conviction for? POCSO,
POCSO.
section 6. You're in jail.
Yes, in jail.
The jail appeal.
Jail appeal.
Yes. Any objection? No. Third learned counsel for not learned counsel. And legal aid counsel for the petitioner. Learned additional PP and learned counsel for respondent number 2. I has been preferred seeking condonation of delay of how many days?
344.
Learned additional PP. Counsel for learned amicus curiae submits that they have no objection to the condonation of the delay. Full stop. Having perused the reasons stated in the IA, court is inclined to condone the delay in preferring the connected jail appeal. Accordingly, the delay stands condoned. IA stands disposed of. Yeah, okay.
Upright.
No time for hearing now.
It's not yet admitted, not yet admitted. Not
What?
yet admitted, Lord.
Of course not, because it is, has to be
Yes, Lord.
listed.
So it.
It has to be registered and listed.
Well, we are all hearing people. Oh, good. See, my lord, time constraint, my lord. So can we have some date all, well,
Yes, you can take your dates. On a hearing day,
yes,
so many miscellaneous matters are listed.
yeah, absolutely.
It's the same thing.
No, my
Like,
lord, we have been observing it since morning, my lord. We'll take the date, my lord.
Yes.
Amin Loilo. He has come, my lord.